Good morning. My name is Hayward Dykes. I'm going to call to order the magistrate docket for May 13th, 2026. If you have a cell phone, please turn it off or put it on vibrate. We'll go ahead and start with the first case on the docket is Betty Adams, case number 26682. And is anyone here for Miss Adams? Okay. Officer Knudsen,
Yes, sir.
whenever you're ready.
All right, Your Honor,
Well, hold on. Let me do this. Forgot to do this.
Swear me
Anyone,
in.
yeah, let me go ahead and swear everybody in. Anybody who plans to present evidence or testimony this morning, if you'll please stand and raise your right hand. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you all. All right, sorry about that, Officer Knudsen,
You're fine.
whenever you're ready.
Okay, Your Honor, my name is Nicole Knudsen, and I'm a parking enforcement officer for Walton County Code Compliance. On April 12th, 2026, I observed a red Jeep Renegade, Florida tag number HPQ V94, parked at the Scenic Gulf Drive Regional Beach Access. I observed that the vehicle was parked in the low-speed vehicle-only parking space, which is Ordinance 20-14, signage parking. I proceeded to take photos of the violation, and I wrote a citation and placed it under the windshield wiper blade. I have provided copies of the photos I took, as well as copies of the ordinance I used to issue the citation.
Do you have those with
Yes,
you?
sir.
All right, if you want to present those. All right, thank you. I was handed a copy of Ordinance 20-14, designated no parking areas, highlighted with sub C, specific use parking areas highlighted. And I have photographs of parking area with the low-speed vehicle parking only. So no contact was made with the driver of the vehicle?
No, Your Honor.
Okay. And did we have, I see some people coming, are any of these ladies Miss White? Okay. All right. I got multiple photos of the Jeep with Florida tag. And then a printout showing a matching of the vehicle search with the tag of the Jeep in the picture, showing ownership. That shows title owners as Betty Adams, and then the registrar as Gail Adams.
There's actually 4 sheets in there that came back when I ran.
Oh, okay, and a
Yeah.
Gail Franklin Adams. And then, okay.
Her name's on the first page.
Yeah, I see that. All right, did anybody else come in while I had my head down? No? All right, anything else, Officer Knudsen?
No, sir.
All right, thank you, ma'am. I'll go ahead and close the evidence portion based on the testimony and evidence presented. I'll find that there has been sufficient evidence to show that an infraction occurred in violation of Walton County ordinances. Improper parking were prohibited, section 20-14. I'll order that a $100 fine, $50 clerk administrative fee, and a $25 clerk processing fee and provide that the $175 must be paid within the next 30 days.
Can I be excused, Your Honor? That was my only
Yep.
case.
Yes, ma'am.
Thank you.
Thank you. You're trying to save paper? I was like, well, maybe I'm missing something. All right, our next case is 260655 Emerald Coast Beach Services. We have Officer John Guard, failure to clean up after a bonfire. Is anybody here on, I'm sorry. Yep. Is anyone here on behalf of Emerald Coast Beach Services? All right. Sir, if you want to grab a seat right there, I'll allow the officer to present, and then you can ask any questions of Officer Guard, and then I'll allow you to present any testimony evidence. All right, whenever you're ready.
Sir? All right. On 4/11/2026, approximately 8:30 a.m., observed bonfire remnants on the beach at 5753 West County Highway 38, Fort Panic. I cleaned up the remnants that filled the bottom of a 5-gallon bucket. Photos were taken of the area of the remnants. I checked the GPS pin and the bonfire permit. It came back to Emerald Coast Beach Service. The remnants found were still warm to the touch. The remnants were removed. Emerald Coast Emerald Coast Beach Services was contacted, where I spoke to the owner, Mr. Will. I notified him he'd be receiving a citation for the bonfire remnants found on the beach, which is violation of ordinance 22-54B1D, failure to clean up after bonfire. I'm presenting an evidence, the photos of the beach as I found it, and as I dug with my beach rake, the remnants was buried underneath the sand. When I got all the remnants out from underneath the sand, like I said, it filled up almost the half of the 5-gallon bucket that you have there in the pictures. There's a copy of the citation on the back, and there's also GPS pin that shows where the bonfire was, that the night shift code person pinned the fire there. And when I checked the GPS pin, it came back to Beach Coast Service, Emerald Coast Beach Services bonfire permit.
All right. And the permit was issued for the previous day, or the night before?
Correct.
Okay. All right. And sir, what's your name?
My name is Will.
All right. Will what?
Will use Citations.
Okay. Do you have any questions for Officer Guard at this time? Okay. Thank you, Officer Guard.
Thank you.
You can grab a seat, and do you mind if I just call you Mr. Will?
Yes.
Okay. Mr. Will, if you want to come on up to the podium, and then you were sworn in earlier, I believe. If you have any testimony and evidence you wish me to consider this morning, now's the time to present it.
Yes, sir. Good morning. So I do have evidence from whenever we received the call from the code compliance that our team left the remainings of the bonfire. I called them right away, and they already sent me right away. It's dated picture still in the truck, bonfire pit with the ashes and everything still in there. And this is our first bonfire violation in 6 years. We train our team. This is the biggest no-no. We cannot leave anything on the beach. We cannot put anything in the trash bags or anything. So I'm very strict on my guys and team to make sure they don't do that. And I have evidence that they were shocked that something was discovered, under this, dug in the sand and all that. So I can represent that to you to show that.
Have you shown it to Officer Guard yet? Have you seen that, Officer Guard? Okay. You want to hand that to Officer Guard before handing it to me?
When I called the office code compliance, they said just represent it here, to bring it here, whatever we have to as evidence. So that's
All right.
what we have.
I'll be happy to take that into evidence if you want to go ahead and hand that to me. We'll mark this as,
And it shows the date right away on the 11th. It was
Okay.
whenever I received that phone call, they did that. And it shows everything still full. And
understood. Okay. We'll just mark this as Exhibit A. You can go back. All right. So Mr. Will, you don't deny the fact that there was a bonfire at that location, that,
No, yeah, we did have a fire. Everything was like, yes. I'm just, I assume could be maybe from the previous fire, from previous day or something, because if even the same location, you know, whenever you burn a fire, the sand gets so hot in that location, so it can, you know, remain as heated for a long time. Plus, I do believe, you know, it could be just the same location pointed this few days before the same fire happened, or somebody dug something underneath, or something like that. But this is not our, as I, you know,
Yeah,
represented
understood.
it.
yeah,
that-
and I believe Officer Guard has already testified that it was warm to the touch whenever he removed the, Officer Guard, do you recall what brought your attention? Did you just go there to check? Is it common practice just to go check?
Every
after?
morning we check the bonfires. They're GPS pinned, so
Right.
we go to that pin. We check for any remnants left, and there was some on top, and then I took my rake and I raked the ground, and that's where they were all pretty much underneath the sand. But when I touched the sand and what coals were left, they were still warm.
Yeah, and this was 8:15 a.m. is what was indicated
Correct.
on the, okay. All right.
And also, I'm sorry,
Go ahead.
the another thing, whenever they checked for the permit, the officer that night, it was already dark. It was like after 8 o'clock or 8 o'clock whenever they pinned it or something. So I don't think they could have seen that this previous fires before, there was something already underneath there or something as well, could be buried before, because the permit was checked and pinned at the same location. It was already dark. So just
Mr. or Officer Guard, any comment on that? I mean,
The officers, when they go pin, they stand over the fire and they check it. They look for if there's anything, because what they do, if there is remnants there from another fire, they'll take photographs of it and note that in the bottom of the permit area.
right. So it's not necessarily uncommon to have fires in the same or generally the same location, but you guys go out, check that to try to, I guess, for lack of a better term, have contamination from one.
Right,
Right.
that's why they check it to try to alleviate multiple fires. And if there is remnants there from another fire, they'll take a picture of it and they'll note it
Okay,
at the
understood.
bottom of the permit.
All right. Any other, and I'll give you last questions or comments, Mr. Will, if you have any. All right,
I just would like to dispute that.
understood. All right, thank you, gentlemen. You can both grab a seat. I'll go ahead and close the evidence portion of this hearing based on the testimony and evidence presented by both the vendor, Emerald Coast Beach Services, as well as the county. I do find that there is sufficient evidence to show that an infraction occurred and a violation of the 2017-05 and 2013-04 failure to clean up after a bonfire. Based on the infraction, there's a $500 fine, a $50 administrative fee, and a $25 clerk processing fee for a total of $575. Mr. Will, based on the amount, could you pay that within 30 days, or do you need more time? Yes. Within 30 days? Okay. I'll order that it needs to be paid within 30 days. And I've signed that order, and you'll get a copy of that order, Mr. Will, and that'll conclude your case. Our last case that we have is 26049, Stephen Gilbert, and we have Officer Schweiderick.
Frederick, yes.
Schweiderick.
Mhm.
Good morning.
Good morning, Your Honor.
All right, and are you Mr. Gilbert? Or is somebody here for Mr. Gilbert? I don't see anybody. All right. Officer Schweiderick?
Yes, sir.
I'm gonna,
The morning of I'm
Go
sorry.
ahead, whenever you're ready, sir.
On the morning of February 9th, 2026, I was on routine patrol with the Sheriff's Office of Walton County, and I was patrolling through the area of the neighborhood Walmart on 98 East in Santa Rosa Beach, about 11:30 in the morning, and I noticed a vehicle parked in the no parking area, fire lane area. I waited several minutes to see if somebody would come out of the store to advise me they can't park there. I actually walked into the store, spoke to a person at the store if they knew anybody who had the vehicle. Nobody knew anything. I sat in my car for several more minutes, waiting to see if somebody would come out. No one came out, so I wrote a citation to the vehicle for parking in a no parking area / fire zone. 2023 is the ordinance. And I have photos of the vehicle.
All right, whatever you have this morning to present, I'll go ahead and accept that. Look at that now.
Photo one.
All right. I've been handed 3 photographs of a white 4Runner. Looks like it's parked up on the sidewalk,
Mm-hmm.
right in front of,
Right next to the sign.
yeah.
And even though that is private property, the sheriff's office does maintain jurisdiction over fire lanes and handicap parking spaces.
Okay, and as you stated earlier, no contact with anyone inside the store and no one came out?
Yeah, and I had waited several minutes to see if someone would come out.
Anything additional?
And that's it.
All right,
That's
thank
all,
you,
Your
sir.
Honor.
All right, you can grab a seat. I'll close the evidence portion of the hearing. Did anybody come in? I didn't see anybody come in. Nobody here for Mr. Gilbert? Okay. Based on the testimony and evidence presented, I do find sufficient evidence to show that a violation has occurred, as outlined by Officer Schraderick. The violation of parking violation. The I'll order a $100 fine, $50 clerk administrative fee, and $25 clerk processing fee for a total of $175. And I'll order that the $175 must be paid within the next 30 days.
That is my only case today. May be dismissed.
Yes, sir.
Thank you.
Thank you. All right. I believe that concludes our docket for this morning, so we are adjourned. We good, Gina? Ready? All right. All right, good morning, everybody. I'm going to call to order the May 13th, 2026 Code Compliance Hearing Meeting. My name's Hayward Dykes. I'm the Special Magistrate. We'll be hearing the cases. If you have a cell phone, I'd ask that you either put it on silent or turn it off. The first thing we have on our agenda is, if you can, if you'll please stand with me and we'll do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all. You can grab a seat. Minutes approval. I've reviewed the minutes and signed those. Are there any announcements this morning? Okay. Okay. Yeah, you can stay seated.
We would like to remove item number 20 under the orders to be signed. And the second request is that item number 4, which is a fine reduction for the case 24-00893, be heard first since an agreement has been reached.
Okay. All right, we'll remove, at the request of the county, orders to be signed, number 20 on the agenda. That will be removed. And then, since number 4 seems to be resolved, we'll move that up to first. Are there any other announcements regarding the agenda?
Yes, sir.
All right. At this time, I'll go ahead and swear in all witnesses. So this is for anyone who plans to speak this morning, whether that's, or present evidence. So even if you don't think that you're going to speak, that's fine. Just remind me if you do decide to speak to let me know so I can swear you in. But all those who know they're going to plan to speak this morning, if you'll please stand and raise your right hand. All right. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right. Thank you all. All right. So based on county's request, we'll address case number 24-0893, number 4 on the agenda. Property owner is listed as Baller Investment Group LLC, and this is a request for a fine reduction. My understanding, the county and the property owner have come to a agreement.
Yes, Your Honor.
Okay, and what's that agreement?
The county and the property representative have reached an agreement that the fine be reduced to $4,000 with an additional $50 administration fee imposed.
So $4,000, $50 admin fee, and then how long to pay?
You pay that within 30 days.
Yes.
Okay. All right, and that's the agreement of representative for Baller Investment Group LLC?
Yes, sir.
Okay. Anything else from the county?
No, sir.
All right. Anything else from Baller Investment Group?
Yes, sir.
All right. Anything from anybody in the public have any comments? All right. Not seeing any. Based on the agreement of both the property owner and the county, the property has been brought into compliance, and that's been confirmed by the county. We'll reduce the fine, which is currently accumulated of $35,200 to $4,000. $30 days to pay, $50 administrative fee. Do be aware that if you fail to make the reduced fine payment within the 30 days, it will automatically go back up to the full amount of $35,200.
Sir.
Right, any questions?
Who
from
is
the
that
county?
made to?
That'll be done to the, you probably need to wait a day or two for it to get into the system, is that correct? Yeah, so I would just coordinate with county staff on when that's in
Perfect.
there, and you can make that payment.
Yes, sir,
Right.
thank you.
Thank you all.
Have a good day.
All right, you too. All right. Our next case, now we'll move back to the top of the agenda. This is case number CE 251816. Property owner is listed as Melissa Smith, and the address is 12367 State Highway 30 West, Freeport, Florida. Mr. Ufelder, or I'm sorry, Mr. Hunter. I saw you, Mr. Ufelder, behind you earlier. All right, Mr. Hunter, you're here on behalf of Ms. Smith?
Yes, Your Honor.
Okay. All right. All right, Officer Beza. All right, everybody ready? Okay, let's go.
My name is Officer Uriel Baza with Walton County Code Compliance. For the record, I am submitting my final case report on testimony regarding case number CE-25-01816. This property is located at 12367 State Highway 20 in Freeport. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7. Violations cited are 1.1300A, development approvals, 1.1309C, building permit, and 4.0303, shoreline protection. We received a complaint on October 7th, 2025, regarding a recent code complaint about a fence that was built all the way to the water and setback concerns. On October 9th, 2025, I conducted an inspection at the property where I gathered photos of the property's current condition, including concerns for the fence and structure setbacks. After conducting research, I was able to confirm that a carport was altered around 2018 with no permits found. A survey provided shows the now upgraded enclosed garage is approximately 6.47 feet from the side setbacks, which require 7.5 feet. Further research found photos from the previous listing of the house for sale that do not show the fence going all the way into the Bay Shore Protection Zone, plus other items constructed in the past few years near the bay that were not present, according to the listing's photos. On October 23rd, 2026, a notice of violation was sent certified mail. And October 27, 2026, it was also posted at the property where the property owner was notified of the violations cited and corrective actions required to come into compliance. On December 22nd, 2025, a meeting was held with the property owner's representatives where it was determined and agreed that a survey that shows the shoreline protection zone would be necessary to show what portion is within the 50-foot portion of the code, considering the distance to the bay of the items in question, including a fence, a large planter, a fire pit, and a swing set. On December 30th, 2025, the plans for the garage were reviewed, where it was determined that the lot does not meet the requested 5-foot reduced setback and would need to adhere to the 7.5-foot side setbacks. Plan review has been put on hold for the time being while the property owner seeks a variance. A survey showing the Bay Shoreline Protection Zone has not been provided to clearly identify the items in violation to bring the property into compliance. On March 23rd, 2026, a notice of hearing was sent certified mail and posted at the Southmont Courthouse and the property the following day. The hearing was scheduled in April, where a continuance was provided to today's date. Photos in your package show the initial inspection and the pre-hearing conditions with the violations still existing. I would like to submit my packet into evidence.
Okay. Have you provided a packet to Ms. Smith's counsel? Have you had an opportunity to review it? Any objections?
Yes, Your Honor, we have no objection to it.
Okay, we'll accept that into evidence as County's Exhibit 1. All right. Anything else, Officer Baza?
I can do the recommendation, or if you want to hold off
let's-
on that.
Yeah, let's wait.
Okay.
All right, do you have any questions for Officer Baza?
Yes, Your Honor.
All right, go ahead.
Can y'all hear me back there? Okay. Good morning, Mr. Baza.
Good morning.
I've got a few questions for
Okay.
you. Now, you're aware that code enforcement proceedings are penal in nature, right?
Right.
That means that effectively you're seeking a punishment against a homeowner and the assessment of a fine.
Sure.
So when we're in these types of situations, the burden of proof is always on code enforcement, right?
Can be.
Now you say you can't be, code enforcement is the one bringing the violation, correct?
We are.
Okay. So a portion of this case was actually previously investigated by Code Officer Drew Galloway, right?
Correct.
Now, Mr. Galloway, he's no longer employed with code enforcement.
That's right.
But during his previous investigation, Mr. Galloway was advised that he was unable to issue any violation regarding the decking specifically on this property.
Correct.
And that's because code enforcement isn't able to determine when that deck was actually built, right?
That's right.
So the deck is a structure that's actively impacting the shoreline protection zone, correct?
Yes, sir.
But it doesn't matter just because it predates that when that zone actually went into place.
Say that again.
Now, whether or not that deck is actually impacting the shoreline protection zone doesn't really matter since you can't determine when the deck was actually put in the first place, right?
I don't know if it, I wouldn't say it doesn't matter, but we can't prove when it was, installed
In terms of this
prior
violation.
to the 1997 Land Development Code.
Right, so in terms of this violation, the actual deck itself doesn't matter.
Sure.
So I want to start by talking about the last violation on that list, that shoreline protection violation, the 4.03.03. So that's just a violation that requires the property owner to remove any structure within the shoreline protection zone, excluding that main deck, right?
Right.
So typically the shoreline protection zone, it encompasses 50 feet upland from the mean high water line.
That's right.
So that depth, it changes, right?
Depending on where the high mean water line is, that's what the survey that was requested was for.
Well, I'm talking about the depth of a lot changing where that shoreline protection zone
It
is.
can affect it. It could be a reduced percentage depending on the lot size.
So this lot size is actually below 200 feet, right?
I don't believe so. I think we've done the math. I think it does qualify potentially for a reduced setback. I think it was 43 feet.
Well, the lot depth specifically in this case is roughly 188 feet, right?
If you say so. I don't have it right now.
So if it's less than 200 feet, a lot is only subject to a 25-foot buffer or a 25% buffer, depending on which one's greater.
Whichever's greater.
So on this one, the shoreline protection zone would be roughly 40-odd feet, right?
Probably about 43.
So you mentioned you requested a survey. Does code enforcement have any survey evidencing a mean high water line?
We do. It just doesn't show the shoreline protection zone,
So
50 foot inward.
So we don't have any survey currently showing where the shoreline protection zone is on this property, right?
That's right.
And you mentioned earlier that a survey was requested by the applicant, right? The property owner.
The survey was requested between a meeting between code compliance and y'all's representative.
Well, specifically it was requested that the property owner be the one to furnish that survey, right?
Right.
I want to look at your case notes really quick. You just put into evidence. On your case notes for December 22nd of 2025, it states that Gary's team will obtain a survey showing the high mean water line to determine whether or not a large swing set will need to be removed and how far it will need to if it is in the protection zone. It's on page 13 of 15.
Well, I have the letter from the attorney on Exhibit 14, where he states, "Please allow this letter to serve as a follow-up of our meeting in the above referenced matter. We have agreed that we will obtain a survey showing the mean high water line, which is the relevant marker for determining whether or not the swing which is the subject of a portion of this code, action is actually within the 50-foot. We have agreed, and then he goes further into, but, yeah, it was agreed. He's specifying on the swing set, but, as I recall, it wasn't just necessarily for the swing set. It was just, we will obtain a survey to show what's within that 50-foot landward.
Well, I just want to make sure, both that letter you just read and your case notes, they only mention the swing set as a cost for that survey, correct?
That's what they mentioned, yes.
Okay.
In my case notes, I referenced this particular statement.
Okay. So you and I can both agree that swing set has been removed from the property.
It has.
So pursuant to these two documents, a survey wouldn't matter for that swing set since it's gone.
Well, my question would be, why would you request only for one particular item?
Well, I'm looking directly at just these two
Well, that's
documents.
just a
right now.
statement provided by you, but I was in that meeting and it was stated that a survey would be provided, not specific to one item.
So I want to make sure I'm getting this right. Before today's hearing, there is no survey showing where the shoreline protection zone is on this property
Correct.
currently.
Right.
But the property owner was still charged with a violation of the shoreline protection zone without your office knowing where the shoreline protection zone was, right?
And as we've read, that was supposed to be provided.
I'm talking about the inception of this code investigation. When you charged the property owner with a violation of the shoreline protection zone, you did not know where it was.
No.
Okay. Another item that you list in that violation for the shoreline protection zone is the removal of a fire pit, right?
Right.
You'd also agree that it was determined that the fire pit in the shoreline protection zone could stay.
At that time, I don't know what decisions were being made as far as, or who had the authorization to make those declarations. I know that after referencing back to our planning department, it was agreed that those items were not a part of non-conforming items. They were an addition, expansion to those non-conformities, and they would have to be removed.
So where do you indicate in your code case report that it was no longer determined to be okay?
Give me 1 second. If you look at Exhibit 23, this was an email sent from my supervisor, Georgina Hicks, and this was in relation to a meeting that we had with our planning department. And a email was sent to Melissa Ward, Melissa Smith, and other people were copied on that, where it clearly states that after our meeting, that the decision for all the items to be removed were listed on this email.
So this email directly contradicts what our office was told by planning's legal department. Is that correct?
I don't know where, I'm not aware.
So I just want to look directly at your case notes. So it says, a meeting was held at the planning department where Brooke from planning department's legal, Gary and Melissa with Dunlap and Shipman, and I were present, correct?
Yes, sir.
So at that point, our office was told the fire pit was fine. That's yes.
If that was the decision, I had come back from surgery. This meeting was held. I didn't know what decisions were, I didn't know what was even in question. I didn't know if the fence wasn't an item that was in question. There were items that were discussed, but I didn't know we were making a confirmative decision on what. I mean, we didn't even have anybody from planning in that meeting.
So what is your process when you enter notes into your case report?
Can you explain a little bit further what you mean?
So you were talking about how you weren't at that meeting, you don't really know what was
No,
going
I
on.
was at the meeting.
at the meeting.
I didn't know the in-depth details of why that meeting was held.
Okay, but still, you would agree that at that meeting, it was determined that the fire pit could stay, just according to your case report.
I believe so. I'm not 100% on that, but I believe they were discussing the fire pit, determining whether or not it could stay. And at that time, I don't know if it wasn't something that was written, it wasn't something that was signed. I didn't know if it was an actual, we're just discussing this and let's figure it out. Because there were still items that were still in question that we were still trying to determine, and we can't really even figure out, there could be other items in it. There's a shed near that area, but without the actual shoreline protection zone survey, we can't even move further with it.
And that's a survey for the shoreline protection zone that the county does not have, correct?
Right.
Okay.
That we were informed we were gonna get.
So you'd understand that, let's say for a moment, that you allege that the fire pit can no longer stay in the shoreline protection zone. Is that because it is a structure within the shoreline protection zone?
Correct.
What makes a pile of rocks a structure?
Well, I don't know if it would be considered structure, but it would definitely affect stormwater. If we got a large rain, hurricane or anything, gravel is not permanent, could definitely go into the bay. So it's definitely a concern.
So during your investigation for this specific code violation, did you ever look to see if that pile of rocks that made the fire pit, if they were cemented together?
No.
So as far as you know, we could just pick it up, move it to the side.
Do you know?
Yes.
It's cemented?
No, it's not.
Oh, okay.
So my question to you then is, if something can be picked up, taken away piece by piece, how is that a structure?
Well, again, it becomes, if it can run off into the bay, it becomes that we're trying to protect the bay. So it's definitely a concern. As you said, it's not cemented and it's not glued together. It could easily, run into the bay.
So we're talking a lot right now about stormwater runoff, but I want to focus specifically on the shoreline protection zone.
Right.
And I'd say the three items you specifically listed in this code violation. That was a fence, yes,
Yes.
the fire pit,
Right.
and loose gravel.
Loose gravel. There was at the time a wall that was removed and a swing set that was removed.
But those are no longer in discussion for today's case.
Right.
So I want to talk specifically about that fence. So that fence that you're referring to, those are wooden planter boxes, right?
Well, I'm talking about the fence and the planter.
Okay, so for the fence, do you know if that fence required any fill activity?
If it required fill activity,
Fill activity, yes.
you're talking about the fence that's all the way alongside the side of the property?
The fence that you're alleging the violation on.
Okay. No, I'm not even sure what you mean.
So fill activity, whenever you install the fence, if there's any fill activity, do you know whether or not that was actually present when the fence was installed?
I'm still, I don't know what you mean about filling in on a fence.
So I'll explain. So under section 4.03.03A7, a fence that is constructed where no fill activity is present is actually permitted within the shoreline protection zone. So my question to you is, do you know whether or not fill activity was present when that fence was installed?
No, I'm not aware what was done when it was installed.
Okay. So do you have any violation right now against the wooden planter boxes that are
Mr. What was that? I'm just looking up that.
the section code?
Yeah.
4.03.03A7.
Thank you. Go ahead.
So is there any violation right now being alleged for the wooden planter boxes?
Well, again, if the idea is that there's enough doubt considering the location of these items. I mean, they're probably maybe 3 feet away from the riprap, that we require that shoreline protection zone survey to clearly identify what's in violation. If you provide that survey and it shows that the planter is not in violation, then it's not in violation. But without that survey, we can't even really determine what is or isn't. Right now, there's enough doubt considering the location to where that was required. And at the time, we were, informed that we would get it.
So I want to redirect you back to my question, which was, right now, during this hearing, is there a current violation being alleged about the wooden planter boxes located on the deck?
About the planter and the actual fence that goes alongside the whole property line.
Okay, so that's a yes,
Yes.
for the record.
Right.
Now, you're aware that during Mr. Galloway's previous investigation in this case, that wooden planter box was approved by him.
So I have his code case right here, his detail report. On 2/12/2025, it says a reinspection revealed the new survey is complete, showing the new fence is 1 foot 6 inch on subject property. So I'm assuming it was encroaching the property line. The fence will be cut back to the corner marker on the east side of the property. Hedge will replace fence to deter canine crossing over. Photo entered to the case file. Prior to this case being closed, there was never any evidence, photos of what was actually installed in that area. In this case, it says a hedge will be replaced. Now, I don't know what you consider a hedge, but what I consider a hedge is an actual plant being installed into the ground. Would you agree?
I would agree, except that this specific area is on top of a deck, right?
So it's not a hedge.
I want to make sure this is just very clear. Whenever Drew Galloway closed out this case, those wooden planter boxes were already installed.
There's no proof of that in his case files.
Well,
I don't know what was actually installed. There's no photo of it. There's no any details as to what was actually installed. The only time he mentions that area is that section where he says a hedge will be installed. Will be installed. Doesn't say what was installed. Never shows a photo of what was installed.
Mr. Baza, you provided some photographs by the property owner during your investigation, right?
I was provided some photos.
Yes, specifically on December, let's see, you were provided an email from the property owners,
Yeah.
which included a screenshot of a picture showing that those planters were installed prior to the date that Mr. Galloway closed out his investigation, right?
No.
You were not.
She provided an image showing Mr. Galloway on the property. They didn't show the hedge or anything back there.
All right.
And if it was, there's no evidence on his end approving it or showing what was actually installed.
But you'd agree that Mr. Galloway was provided notice that the property owner was installing those wooden planter boxes pursuant to her text messages with him, correct? That you were aware of.
The text messages mentions a hedge. It doesn't mention a planter box, anything in reference to a planter box.
Now, Mr. Baza, if code enforcement closes out a case on a property and the case notes say case resolved, you'd agree with me, it's fair for a property owner to assume they are now in compliance, right?
It'd be fair to take that opinion on it, yeah.
Specifically, Mr. Galloway's case says case resolved, correct?
That's what it says.
All right.
Clearly, it's not resolved since we're here.
I just want to ask you, the case report,
You're even seeking a variance for an enclosed garage, so would you agree it shouldn't have been resolved?
Mr. Baza, my question was, that case report says case resolved, yes or no?
Yeah,
Thank you.
it says it.
Now, specifically for this case, for shoreline protection zones, is it common practice for code enforcement to cite a violation of a shoreline protection zone without even knowing where it is?
If there's reasonable doubt,
So that's a yes.
yes.
Okay. So I want to move on to the building permit. So this violation requires that the property owner obtain a building permit for enclosing in, or for a previous owner of the property enclosing in their garage, right?
Yes,
Now, we're not sure exactly when that property was enclosed.
probably around 2018.
In fact, it's between April 2016 and June 2018, right?
Right.
So there is no building department file that shows a permit was applied for during that time frame.
No, sir.
Now, you're aware that building permits aren't required for accessory structures that are under 400 feet, right?
If they don't have electrical and water supply,
Do you know if this garage has electrical or water supply?
I do. Matter of fact, I forgot to get those images for that specifically, but on the listing, it does show several items that would be, producing some kind of power.
So according to you, the Florida Building Code, which does not require power or plumbing for an accessory use to be under 400 feet to require a building permit, according to you, you've got records showing that it actually does have some sort of power going to it.
Right, and I believe it is larger than 400 square feet.
Do you have anything in front of us today showing that the area that was enclosed was more than 400 square feet?
No. I mean, I'm not even gonna lie. I didn't bring too much evidence on that since you guys are seeking a variance on it. I thought if you're seeking a variance, you're pretty much saying we're in violation. So,
All right, sir, you just, hold on, let them finish.
All right, so I want to move on to the last violation.
All right.
Development approval.
Uh-huh.
So this is a citation where the property owner failed to obtain development approvals through the plan department, or the previous property owner failed to obtain a development order to enclose that garage in, right?
mhm.
That's yes.
Yes, sir.
Sorry, just make sure for the
No, you're
record.
good.
So, and like we already stated, property was enclosed, the garage was enclosed somewhere between April 2016 and June 2018, right?
That's correct.
So, did you inquire at all about what the land development code required between June 2016 or April 2016 and June 2018?
Well, most of the land development code is subject to anything that was conducted post 1997. So the land development, the language would be referencing to anything that was done, post 1997.
Well, you're aware that the land development code underwent major revisions, let me find that word, in 2024, right?
I'm not aware. I mean, we do have people from planning here. If you have any questions regarding the land development code and years and dates, I'm sure they're a little bit more, their expertise would probably be more reference to them regarding any planning questions, since I don't work in the planning department.
But I just want to make sure now, during your entire investigation, you never inquired as to what was required by the land development code for development orders on enclosing garages between April of 2016 and June 2018.
No, sir.
Okay. So because of that, you don't have any documentation today showing what the land development code required at that point.
Again, any questions you have regarding the planning and the land development code and dates, and we can reference those questions over to our planning department.
Okay, but just you yourself, you don't.
No, sir.
Okay. So at the end of this, you're aware that a development order is not required for enclosing a garage, right?
So in our section, due to the limitations of not being able to find the actual prior development order or any kind of plan approvals, we would normally do a violation of a post permit for them to do that process. But since I wasn't able to find any kind of approvals or any kind of permits in the past, we move forward with development approvals. That way, whatever needs to be approved can all be done within one approval, whether that's that garage or if they want to include anything else as far as the construction of the land or other sheds that may be in question.
I just want to redirect you back to that question, which was, a development order is not required generally just for enclosing a garage, right?
I don't, again, most of these questions are planning department. So if you have any questions regarding how that process works, the planning department would probably be the best to answer those.
Well, you'd agree with me that under section 1.13.00B3, The alteration of an existing building or structure does not require a development order so long as no change is made to the amount of impervious surface on the site. Did I read that right?
I believe so.
Did you ever examine to see if the impervious area on that site was expanded?
Again, I'm not a plan reviewer, so, and this process has been gone through the planning department, and a planner has reviewed the plans. That process is not on my end. I enforce what the decisions are made as far as the planning department goes. As to the details of what kind of approvals are necessary, or what all they're going to need to be able to obtain these permits, the planning department goes through that process with the property owner. We stay in the mix as to whether, if it's been approved, if it hasn't been approved, where's this in the process, so we can continue the case on whether we can close it or whether we can continue with it. The latest that I've heard on this property regarding that enclosed garage is that the property owner was declined, or at least for right now, it's been on hold because the property owner was seeking a 5-foot reduced setback, which was declined due to the lot size. So it has to adhere to the 7.5 side setbacks. Since then, we haven't had any kind of movement on the BPR because the property owner is going to try to get a variance for that. So for right now, we can't. I mean, it's at a standstill.
So
Is the property owner seeking a variance for this?
they are currently scheduled for one, yes.
Okay.
So going back to my question though, during your entire investigation, you never looked to see if the impervious area of the garage was ever expanded? Yes
Again,
or
this
no?
is planning department. No, I don't do that.
Okay, just so no. So I want to make sure I understand the process for code enforcement.
Right.
So whenever someone calls in a complaint, you go out and investigate it, right?
Yes, sir.
And then based upon that investigation, you issue a citation.
What we do is we gather as much research as we can, and we seek guidance from those experts who can direct us on whether it's a violation or not.
So I want to make sure in this case, you issue them a violation for lack of a development order without knowing if they required a development order in the first place.
That's typically our process for anything that doesn't have, as far as code goes, if it doesn't have any kind of approvals that we can direct our findings to. Typically, if we can find one, we'll do a post permit where they, if they did any alterations to the approved plans. But if we can't find those plans, we can't necessarily say it's a post permit because we don't even know if there is a permit or any kind of approvals. So we request a development approval through our violations. Now, whatever they have to do in depth and detail to qualify for what they're trying to obtain, all that's done through the planning department. Our job is to try to guide the property owner to obtain compliance. We're not ever seeking any kind of fines or fees. Our main goal is to come into compliance. So our job is to guide the property owner to the right department so they can move forward on getting that done.
But all that happens after you've already issued a violation, right?
No, not all the time. Prior to that, we conduct as much research as we can. We reach out to, those experts in that field to see whether or not it would constitute a violation or not. And if the decision is made that is a violation, then we proceed forward.
All right, thank you. No further questions, Your Honor.
Anything else? Let me ask this, Mr. Officer Baza, if the garage is over 400 square feet, regardless of whether it has electricity or plumbing, would it require a permit, or do you know?
Regardless if it's 400 square feet, if it has,
No, if it's over 400 square feet,
yeah, it would.
so if the structure is over 400 square feet, and where did you obtain what's marked as Exhibit 11 in your packet, the rare earth survey?
That was provided to Mr. Galloway in the previous code case. I don't know the depth as to when that survey was conducted.
Well, on the date of it, it looks like in 2025.
25.
So, and just so I'm clear, because I know Mr. Bell, and you went over several things. As it relates to the shoreline protection zone,
Mhm.
there's, there's alleged to be gravel in the shoreline protection zone that the county claims is a violation. Is that correct?
Correct.
Okay. Then there was a fake hedge, and then there was mention of a wooden planter. Are those the same thing?
They're the same thing.
Okay. Have those been removed, or are those still?
They're still there.
Okay. On your last inspection, they were still there. All right. And then there was discussion of the fire pit. I have that. There was mention of the fencing. I saw some photographs in your packet that show a wooden privacy fence. And then there's what appear to be hedges and planters. Is that the hedges and planters we were just speaking about?
Well, they're like some kind of like fake fox hedge. I don't know. They're not actual.
Yeah, it looks like it's to shield.
Yeah, just to shield and divide.
Okay. But that's what we're talking about. These here?
Yes, sir.
Yes, Ron.
All right. There was also mention of, was there a planter on, is this considered the planter on the deck?
Yeah, that's what we're considering, the bench/planter.
Okay. Because I do recall the testimony being there was a planter on the deck, and I wasn't sure, but it looks like there's decking, so that's the one we're talking about. Okay. All right. All right. Mr. Bell, any follow-up questions based on my questions too?
Not based on that, Your Honor.
Okay. All right. Anything else from the county or from you? Or do you have any other witnesses from the county, anyone from planning department?
Yeah, we have somebody from the planning department just to kind of provide their expertise on the shoreline protection zone. Brad Bond.
All right. All right, Mr. Bond, were you sworn in earlier?
Yes, sir.
All right. What testimony do you have to present?
Just based on historical aerials, this property's been impacted prior to 96 or 97. So, any of the existing stuff might be, existing nonconformities, and the code doesn't allow for any expansion of those. It did qualify for the reduced shoreline buffer. I think our rough numbers were around 47 foot. Anything that was added post 97 within that 47 foot wouldn't be allowed.
Have you looked at the survey that's marked as Exhibit 11, the 2025 property survey from Rare Earth?
Yeah, I believe I've seen this one.
So, based on the aerials that you've seen in that survey, I mean, are you in a position to identify what's in or out of the shoreline protection zone?
I mean, without having the actual numbers or the line drawn on the map, I don't feel comfortable stating for sure what structures are in it.
Okay. I'll allow Mr. Bell, go ahead if you have any questions.
Just real quick, I wanted to just Brad Bond. Could you state your position in planning department and your expertise?
Yeah, I'm the environmental planner for the planning department.
All right. Anything else?
No.
Is that it? Okay. Go ahead, Mr. Bell.
So, Mr. Bond, I just want to focus on the last thing you said, that looking at that survey, you wouldn't feel comfortable right now identifying what is exactly within that shoreline protection zone. Is that what you said?
Yeah, not without having a surveyor or engineer kind of drawing that line to scale. I don't have that expertise to draw those lines, to make that kind of determination.
Understandable.
Yeah.
So, you mentioned that there are certain areas that are already impacting the shoreline protection zone. Are you referencing the deck that predated the shoreline protection zone?
Essentially, we don't have any clear aerials that show that deck. We can see in some aerials fuzzy images of what looks to be cleared area. You can clearly see trees kind of more towards the road, and then it's a lighter color that would represent being cleared. And it shows the dock but you can't really see that pier. It's along the shoreline.
So question for you about the impact on the shoreline protection zone. If you have a deck already there and you place, let's say, a bench on top of it, does that bench also impact the shoreline protection zone?
That's it's a little bit above my pay grade to make that kind of determination. The code just allows no expansion of that. Yeah,
And when you say expansion, what do you mean?
just adding anything new to it, fence, any structures,
Structures?
thing.
Okay, thank you.
And I did want to mention the section of chapter 4 that you referenced about fences.
Yeah.
That applies to rivers and creeks, not the Bayshore Protection Zone.
So a question about that, actually. So looking at that aerial footage, or not aerial footage, were you able to review the pictures that were in that document submitted by Officer Baza?
I did not.
Okay, never mind that. I had a few questions for you on it. Never mind, thank you.
Yep.
All right, Officer Baza, anything else, any questions or anything I need to hear from?
No,
Mr.
sir.
Bond? Okay. Anyone else from, the county on this case?
I believe that's it, unless they have any questions for our planning department.
I did, just so I know, and this is gonna be for, the county or Mr. Bell, the survey that we have included in the packet from the county, Exhibit 11, I believe. Let me make sure. The garage that we're speaking of is the structure that's listed as one-story frame garage and utility building on there? Okay. And am I correct that
You're
the way you can, you figure out the square footage is you multiply the length by the width, correct?
That's right.
Okay. And those numbers are, everybody will agree there's some numbers on there identifying the length and the width of the garage? Okay, thank you. All right, so nobody else from the county? Okay.
sir.
Mr. Bell, do you have any evidence or testimony?
Yes, Your Honor, we've got the one Melissa Ward.
All right,
Or if you can come up.
and Officer Baza, if you want to just grab a seat, that'll allow Ms. Ward, and then if you have any questions for Ms. Ward after, we'll allow you to come up.
Could you please introduce yourself?
My name is Melissa Ward. I'm a certified planner with the American Planning Association for Dunlap and Shipman on behalf of the applicant. And 20 years experience. Okay.
What is your involvement with this project?
We were hired to look into the code violations that were noticed to the property owners. The prior case, which was then closed, and then this case was reopened.
So I want to walk through the three violations one by one, starting with the violation for a development order. On your reading of this violation, what specifically was the problem?
Well, so the code violation is under 1.13.00A and references obtaining development approvals through the planning department. And according to the report, for the unpermitted enclosed garage. And so for clarity, it's not the garage that was enclosed, the workhouse or the utility building was enclosed in 97, and the carport was allegedly enclosed somewhere before the property owners purchased it. So the code, the development activity that they are saying needs a development permit is listed under that section 1300A. It specifically states no development activity may be undertaken and no permit may be issued except as provided in the following subpart unless and until the activity and permitted has either been determined to be conformance with technical standards with the code and has been authorized, issued a final development order pursuant to the provisions of the code. So a final development order is an entirely different process than a building permit. If you read under subsection B of the exceptions, which was not listed in this complaint, is specifically item number 3, an alteration of an existing building or structure so long as no change is made to its gross floor area or the amount of impervious surface on the site. So the enclosed utility building was already impervious surface, and the existing carport 97 was existing impervious surface. Therefore, it is my opinion that they would not have been required to get a development order, which most building permits related to a single-family home do not require a development order anyway, and it's not appropriate to be a code violation.
All right, so I want to move on to that second violation for the
Sorry,
building.
just so I got, what was that section you just read from?
1.13.00B, under exceptions, item number 3.
Let me just get there real fast. You said sub B.
Yes, sir. Oh, do you want to hand?
We've got a copy if you want one, Your Honor.
Yeah, that'd be great. I mean, I'm trying to keep up, I'm just making sure.
Tab 4.
All right, thank you. And does the county have one of these? If you want to give them a copy so they can track as well. All right, sorry about that, go ahead.
Okay.
So pursuant to that subsection, would a development order have been required for this project?
It's a single-family lot with a single-family house, no development order, no development permit, development order would be required. And in 1997, they would have moved forward with construction, and any enclosures after that 97 date of a carport would have required potentially a building permit. And depending on the time frame throughout the county's changes of the land development code, it could have looked like anything. So the requirement there may have been that they had to have a permit, but it would not, depending on when certain aspects of that was applied and when that was done, it may not have required any other review other than a building permit review.
So I want to move on to that second violation for the building permit. Do you know if the current homeowners have already applied for a building permit?
Yes, they have.
Do you know what status that permit
Let
is
me
in?
make a correction for accuracy. They have applied for a building permit and floodplain review application, what is necessary today under the code to go through the planning department before you can get a building permit. That application has been made.
And for this violation, the corrective action would be obtaining that building permit, correct?
That is correct.
Now, would a building permit have been required for this specific enclosure between 2016 and 2018?
So there are questionable aspects, and I've testified to this multiple times at both
Hold on one
variance
second,
boards.
just so I'm clear. When you say for this enclosure, you're talking about just the carport?
The
portion?
carport is at
Okay,
issue.
Okay, right.
Yeah. So for clarity, we'll look at tab number, sorry, let me get there. Tab number 7. And I've testified multiple times for other instances where we had to go for the zoning board of adjustments on the same issue, is that the policies have changed, and these policies are not necessarily related to what was in the code at the time, but the policies in general. So if a person was to apply for a building permit or to inquire whether or not they needed one, they would contact the building department, and the building department would direct them associated. The building department, until recently, would tell you that if you were enclosing something less than 400 square feet and not using, no heated and cooled space, that you did not need a building permit. And only until recently did they direct people to the planning department once they developed their development review process for all single-family home building permits. And the reference to that under tab 7 is under permit rules. This is a website page that currently exists on the county's website that talks about accessory uses which are not heated or cooled and do not require a building permit constructed by the property owner outside the coastal building zone. That building zone is south of the bay. This is north of the bay. Accessories exempted by this rule included are, and if you list down the list, storage buildings and carports. This is a confusing factor when you're talking about whether or not a building permit is required because it specifically says it would be exempted. So in the interest of clarifying the matter, we had multiple meetings with the planning department to discuss this issue and in conjunction with the other item.
So at this point, do you know the status of where the building permit is within the county? Of what state it's at?
So we made application for the building permit and floodplain review of the, and this is an after-the-fact permit, so it's after-the-fact construction, meaning that we had plans drawn up by an architect and submitted them in order to show what's already there, what the property owners purchased. So we submitted that to the department. There was a communication in email that the property, under that building permit review, that the property did not qualify for the administrative 5-foot side setback. So a part of that discussion was related to, in order to move the permit along, they would require us to get a variance. And in that particular, as we were developing that variance, we noted that the rule for properties of this nature was unchanged up until 2000, I want to say it's 23, I have it on my tablet, that if it was platted before 1975, it was administratively given a 5-foot side setback. This plat goes back to 1954. But they changed that a few years ago to say that it had to be less than 10,000 square feet, which was not previously in the code. So at the time the carport, the foundation, that impervious surface was there, that 5-foot setback was applicable, and it continued on until only recently. So because of that, we are forced to go for a variance, and that is the delay on the building permit review.
When's your variance hearing?
This month.
The 28th.
The 4th, yeah, the 4th. The 4th Thursday of the month, yes. And the request for the continuance that was mentioned by the code enforcement officer was to continue this hearing past that date so that all issues might be resolved. That was obviously not approved.
All right.
Now I want to move on to this last violation for the shoreline protection zone. Were you present at the meeting that we discussed in length on December 22nd of 2025?
Yes.
Do you know why the fire pit was originally declared that it was allowed to stay within the shoreline protection zone?
So the property back in the 90s had a boat ramp made out of concrete, which is still there. It was not removed. And so the gravel and the fire pit are just sitting on top of that. And it was determined that it did not expand the nonconformity. It's laying on top of it, but it doesn't expand it. Expansion usually of a nonconformity is in the impervious surface area.
So specifically with that fire pit, when you're talking about the impervious
area.
Impervious surface area, there's a reason I'm not a planner. So for the impervious surface area, at any point, any of the items that are mentioned as a violation, do they expand any nonconforming use?
With the pit itself is, just for clarity, the fire pit are garden stackable bricks that have a lip, and they are formed in a circle. They are not cemented, tied down, or connected with rebar. And they are sitting on top of gravel, which is sitting on top of concrete. It was determined it does not increase the impervious surface ratio. It does not change or challenge the stormwater runoff, and it does not have the potential for other outgrowths from that.
And are you aware of why there is now a different conclusion from what was originally decided during that meeting?
Well, so no, the code enforcement officer referenced the email that we received from Georgina Hicks. That came about after we requested the continuance to postpone this magistrate hearing until after the zoning board of adjustment hearing for the variance. And they reintroduced a bunch of things that had already been slated off of the code violation. Specifically, the only things that we were dealing with is the swing, which is what the response to the survey was about, and the enclosure of the carport. So relatably, I had it here somewhere. The items that were listed in the fences, the box structure with a faux hedge, the fire pit, and the gravel being reintroduced into it were removed in that meeting. They determined that they were not considered violations because the fence and the faux hedge was on top of the existing platform. The platform is considered grandfathered or allowed as it was already there, and it was not increasing the impervious surface area or increasing any additional impact into the shoreline buffer, just like the fire pit and the gravel. And the relationship to the swing, the question was, the swing potentially was not of an issue because, but they considered it because it was bolted down to the dock. The question was whether or not that was a problem. And so it was a suggestion, Mr. Shipman pondered if they had that, because they don't even know where the shoreline buffer extends to, as whether or not that was applicable. Well, in response to that, the property owner decided they would remove the swing. It was removed to remove any other questions about the shoreline buffer zone because it was no longer applicable.
Right. And do you have any other information related to the shoreline protection zone that we've not already discussed?
Well, I would only say this. The shoreline protection zone is meant to encourage or to require that when you have vacant wooded land, that you protect that area that's in vegetation to reduce runoff into the bay. And the situation on this property that predates any of this stuff is that there is not just a stormwater wall with a riprap in front of it towards the bay, but back behind it, the depth of that deck is an upland retaining wall, which that deck is not just for decoration, that's a cap over that retaining area. So that full area was impacted way before the language about the shoreline protection zone. And therefore, those things are a part of that entirety of looking at what those impacts are. Where you talk about no development in the shoreline protection zone, that is the bay, subsection B, which is applicable. It does speak to seawalls, and it speaks to them having the riprap, and all of that structure there is a part of that seawall structure.
When you say part of that, what are we talking about, the wood deck, or what all are we?
The deck is actually a cap that
Okay.
connects the two seawalls or the two retaining walls together.
Now, Ms. Ward, are you aware if Drew Galloway was ever given any evidence of these faux hedges prior to closing out his investigation?
The applicant, or the property owner, Melissa Smith and Amanda Brown, so the original case was, I believe, under Amanda Brown, but they both own it, was providing documentation to Drew. We have copies of that in communication emails. I did not bring them today, my apologies. They were discussing with them the fence that they made them take down. The issue that they needed to resolve was protection of their property, so they were allowed to put up the benches with the plantings. And there was, and they had sent pictures to the code enforcement officer at the time.
All right, thank you. No further questions for Ms. Ward.
Okay. Officer Baza, do you have any questions for Ms. Ward? Or anyone from the county have questions for Ms. Ward at this time? Any questions?
Yes, I believe Ms. Kelly Schultz.
Good morning, sir.
Good morning.
Kelly Schultz, I'm the Deputy Planning Director. Just a couple of points that I think it's important for you to understand is planning has required reviews for single-family residences the entire time I've worked for the county, which has been over 5 months. There was a lot of confusion on the building department's website because they did have the language about the 400-foot structures or less did not require permits north of the bay. And because of that, we asked them to please cooperate with our staff to help our employees and our citizens understand that just because a permit's not required doesn't mean the planning review is also not required. And it's just for situations like this. We look at everything on the site. We look for setbacks. We look for any kind of environmental issues, whether it be shoreline, wetlands, flood zone. There might be preservation on the property, just whatever might be on the site that would impact the project that they wish to proceed with. The other thing is that I wasn't privy to all the conversations related to this particular property, but generally, the way our staff is looking at nonconformities going forward is that if there was something there prior to the magic 1996 date, then it's nonconforming. Anything else after that is subject to current code. So I know it does seem a little silly with the gravel over the concrete, but gravel over the concrete is something new. A fire pit is something new. So therefore, it's our position that, we don't have any language in the code that helps us draw that line of, okay, so what's okay to continue to add in the shoreline buffer and what's not. So basically, that boat ramp was there. It can stay there. It's great. But anything added to the site other than what was there November of 1996 is going to be looked at as an additional encroachment.
So what about the property owner's argument, which is part of their argument that this does not increase the impervious area, therefore it's not an enlargement?
Impervious area and encroachments can be two completely different things. They can both exist. They can coexist, or they can be completely separate. This is north of the bay. It's single family, so it's not in one of the conservation zones where we would look at ISR for single family. So therefore, I appreciate and understand their position on that, but I don't think that the ISR is applicable in this particular situation. What we're looking at, and we're trying to be consistent across the board, is the increase in the nonconformity.
Okay, and can you show me a reference in the code where that's specific, that's the criteria, that would be? Because I also have the argument made by the property owner that this had been previously reviewed by a prior code enforcement officer, Mr. Galloway, who we all agree is no longer
Right.
with the county, but that this was reviewed and appeared to have been closed out. What would be the rebuttal to that, hey, this was reviewed and at the time we were in compliance, or we were told we weren't, there was no issue, and then the property owners move on, and then now they're facing
Yes,
these
sir.
same claims again?
Certainly, and so I see this as a two-part response. First of all, yes, I can absolutely get you that reference to the code in Chapter 1 under hardships. I'll have to pull my land development code to be able to get you the exact reference.
Okay.
However, as far as me responding to anything related to what Mr. Galloway did or didn't do, what notes or what actions were taken by him as a code officer, I can't respond to that. I'm not privy to any of that information.
All right, understood. Let me, so are you only here to speak about the shoreline protection, or do you have any testimony or evidence you wish to present related to the, I'll just call it the garage?
Nothing related to the garage, sir.
Okay.
5 months? Oh, okay, Brooke, thank you. Brooke just told me that I said I've been here for 5 months. I've
did
been here
say
5
that.
years, so
Okay.
I apologize for that. I
A lot
misspoke.
longer than 5 months. All right, Mr. Bell, do you have any questions for Ms. Schultz?
Yes. Ms. Schultz, I can appreciate you being here for 5 years. I thought you were making a joke. So, question about, you just referenced hardships.
Yes.
So, that's dealing specifically with non-conforming uses, correct?
Right.
So, how does that tie into the impervious surface area being expanded?
So I don't even know that they expanded the impervious surface area. They may have kept the concrete, the gravel right over where the boat ramp is. But the fact that they've added something to that site that wasn't there in 1996 is where we see the expansion of the nonconformity.
Okay, so it's, if you have something that's non-conforming, you add anything to it, it is now something that's expanding the impervious use. Let's say it's a chair, that expands the impervious use.
Well, and I have to respectfully say that I don't even want to call it expansion of an impervious use. It's just an expansion of what's on the site. So it's an expansion of the use in general. So yeah, I mean, it's, you start splitting hairs when you start trying to say, well, common sense says that this extra gravel is going over something that's already there that's concrete. Okay, the code doesn't give us that authority to say you can add something else in this shoreline buffer. The code is, and you're picking and you're going through and you're looking at it from a totality perspective of, okay, how are we going to put all these pieces of the puzzle together? And again, a lot of record date being 1996, the use being there prior to that date, the use talking about the boat ramp. Anything beyond that would be, in our department's perspective, it would be an expansion of that nonconformity.
Okay, thank you.
You're welcome.
Thank you, ma'am.
Thank you.
Anything else, Mr. Bell?
One moment, Your Honor. I believe.
Yeah.
While Ms. Ward's looking something up real quick, I'm going to have Amanda Brown come up, Your Honor.
Okay, Ms. Brown, if you'll raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, ma'am.
Could you please introduce yourself for the record, spelling
My-
your last name?
My name is Amanda Brown, BROWN. I am co-owner of the property at 12367 Florida State Highway 20 West.
Now, how did you first become acquainted with the code officer, Drew Galloway?
When he arrived on our property to respond to a complaint about potential code violations.
Now, as far as you're aware, was that code investigation closed out?
Yes,
Did you have any conversation with Drew Galloway regarding the fence and faux hedges that are currently on your property?
yes.
How did that conversation occur?
I sent him pictures and text and told him what we were doing and that I would appreciate him coming by the property to give his stamp of approval, if you will. Before we proceeded any further, we wanted to be sure we were in compliance. He agreed that we were, and that was the end of it.
When you say that he agreed that you were in compliance, did that mean he came out to your property and looked at what is currently on the property today and said that was fine?
Correct. Even before that, he mentioned that it would be appropriate to put movable planters in the place where we had to pull the fence back, that would be an appropriate remedy to protecting us, our privacy, and from the animal next door coming into our property. He said that would be an appropriate solution where code was concerned.
So, would you agree with me if I say that the violation that's currently put forth against you is something that was caused by the suggestion of a previous code enforcement officer?
I guess-
Regarding the faux
I guess you
hedges.
could say that, yeah.
But you did put forth those hedges to get Mr. Galloway's stamp of approval.
Correct.
All right, thank you. No further questions, Your Honor.
All right, hold on, Ms. Brown. Officer Baza, do you have any questions for Ms. Brown?
No, sir.
All right, thank you, ma'am.
Nothing further from the property owner, Your Honor.
Okay. Anybody else from the county? And I believe there was a gentleman that stood up in the back from the public that said he may have some information regarding this.
Yeah, I'd like to introduce is the neighbor, the complainant on this subject.
All right. Hold on one second, for some house cleaning. I was handed, tabs 1 through 17 by the, Mr. Bell on behalf of the property owner. County was given a copy of it. Any objections, any issues with this? If not, I'm gonna go ahead and accept this, into evidence as property owner's Exhibit A.
No objection.
Okay.
We also have a copy for the clerk, Your Honor.
All right, great. Just mark that as Exhibit A. County's packet will be marked as County's Exhibit 1. And we're taking those in as composites, so all those are going to come in under one. And then, I'm sorry, sir, can you state your name for the record?
Yes, my name is Ron Vojdani, is Vojdani.
All right. You mind if I call you Mr. Ron?
That would be perfect.
Yes, that would help me
Believe
out
me,
a
that's
little
the best thing I've been called so far, so,
bit. And you're the neighbor?
yes.
Okay. And what evidence or testimony?
Okay, I wanted to bring out some facts. I'm unfortunately a bad neighbor that called and filed a complaint. When Mr. Galloway came out there, I made sure that he knows that my dissatisfaction was that the fence that they have put while we were out of town is in my property. So that's just started all of these, and all he did, he made them remove a section of the fence and install hedges, as you call it, it's a fake hedges. So every time I called and I said, what's the status? Oh, they have 30 days to respond. They have this, they have to move this. I had 30 days because I had some violations myself I had to take care of. So we got all those taken care of. I never heard back. Never knew it's closed or not, so I wrote a complaint letter to the county, said, look, where's my case? I was informed that Mr. Galloway is no longer with the place. So I was lucky that Mr. Baza took over, and we went, and he's been very good helping out. So what I did, I had got a survey, and the neighbors had a survey. I looked at the survey. Their survey wasn't clear enough that they are in my property. So I went to the planning department, and they said, ask for a revised survey. The survey that you have is not the revised one, sir. They have been given the revised one, and I have a copy for everyone here. If you like, can I approach and give it to you?
Do you have one for the county as
Yes,
well as
I do.
Mr. Bell?
They already had that as a,
Well, have you shown it to Mr. Bell?
I mean, I'm gonna give it to you.
Oh, so this is the
No, the
rare-
survey that was-
Hold on. So is this a rare earth survey dated, field date, January 28th, 2025?
No, yes, sir. No, sir. No, Your Honor.
Okay.
This is a revised one for the January 28th. If you notice on the dates back there, it says revised 2/17/25.
Yeah, I've got one here from Rare Earth stamped by Shannon Clatchy.
Yes.
And there is the job number 250012. It says a field date of 1/28/2025, and then over on revisions, there's a 10/26/25 and a February 17th, 20.
Then you do have the new one, yes, Your Honor.
Okay, all right.
Okay.
Yeah, that's already been introduced by both the county
There is a
as well
second
as the
page
property
to
owner.
that. Your Honor, there's a second page to that. I don't know if you have that one or not, which is blown up of the section. Can I bring it to you?
That one I don't know that we have. I do have the enlarged one. Let me see that. Hold on one second. Let's see, okay. Mr. Bell, you want to look at
That's the
this?
blown-up section.
You want to hand that to Mr. Bell?
I want him to look at. It says clearly, adjacent fence corner enters onto Vojdani, which is me, property, 0.27 feet. In other words, the fence that they installed and still is there, it is encroached to my property by 0.27 feet. Now,
heard on that, Your Honor, before we keep going?
Hold on. So before we keep going, I have no authority to deal with
it's okay.
in a
Oh, I
property line
understand, I understand.
dispute or encroachment. So
Your Honor-
where are we going with this as it relates
But
to
I'm
the
going
code
that that
enforcement?
section is going to be gone anyway, because if, I asked Mr. Basil, shall I take them to court myself? They said, no, don't worry, that section is going to be gone anyway, so if that's the case, then that will be fine. Then, I didn't know you had the survey back there, but in 2018, October 2018, Hurricane Michael, took half of the yard. And everything that you see in that section,
What section? I don't know what.
the front, the decking that they're talking about, the decking that they're talking about back there, decking by the bay,
Yes, sir.
all of that was wiped out in 2018, October 2018, by Hurricane Michael. And that deck is connected to my seawall.
All right.
So that should not be there either,
Okay.
okay? And the,
I'll let you, Mr. Bell, I'll let you question him.
Okay.
and present.
Yeah, sure. If he's going to enter that survey into
No, I'm not going to take the survey necessarily at this time into evidence. I think it's just a blow up of what we already have,
yes,
so.
just a blow up.
Okay, go ahead. Anything else from you, Mr. Ron?
No, but he said, that Mr. Basil was saying that he did not have the measurements. 7 by 2 is at the end, the smaller building is what was there before. The whole garage is 44.3 by 16.5, if I can read it right. So that's over 730 square feet for that. And you can clearly see the air conditioning units that's attached to the outside. So I thought maybe these facts will help out with some of this stuff.
Understood. Thank you, sir. Hold on one second.
Sure.
Officer Baza, do you have any other questions for Mr. Ron? All right. Mr. Bell, do you have any specific questions for Mr. Ron? All right. Thank you, sir.
Thank you, Your Honor.
All right. I believe that's all the witnesses from the county. Am I correct?
Yes, that's all we have.
Mr. Bell, any additional witnesses or evidence?
No, Your Honor.
All right. One thing I do want to ask both sides, the variance request that's slated for this month, that's only related to the, as I said earlier, just the garage? Okay. So there's no variance request being sought related to any shoreline protection zone, correct? Okay. All right. What's the county seeking? Or what's the recommendation?
Recommendation is 33 days, which would be June 15th, 2026, to bring the property into compliance, to provide the survey to be able to determine exactly what needs to be removed, the items that need to be removed, to bring the property into compliance. Again, proceeding with the variance board decision to determine how to proceed with that violation. And it's going to be $200 per day if not brought into compliance. And there's a $122 administrative fee.
So to bring the property into compliance, and I want to focus, because it sounds like, and I'll go ahead and show my cards as it relates to, I'm gonna give the property owner the opportunity to be heard on their variance requests. And I think 33 days would give us sufficient time unless there's gonna be an issue related to the hearing that's coming up. But what would need to happen related to the shoreline protection zone? I know the county wants a survey that has that on there, because right now, I mean, nobody's able to tell me whether or not these things are in or outside of the shoreline protection zone.
Yeah, without the shoreline protection zone, it's really hard to say 100% what's in it. I think our position is that there's a reasonable amount of doubt considering the location. If you look at the photos, the planter is probably, I don't know, 2-3 feet away from the riprap. So just with that evidence is sufficient for us as far as the county to move forward on trying to obtain that survey to determine exactly what needs to be removed from the shoreline protection zone.
Okay. But absent them getting the survey, then what would even be the remedial measures the property owner could or should take?
I mean, other than that, I mean, to really determine 100% what's in it, that's just something that would need to be requested. In our position, it's almost if you had like a shed in the setbacks that you can visually see is within that setback. We typically require a survey showing where it needs to be placed. If the fence is the property line per se and the shed is 2 feet away from it, then we consider that enough doubt or consideration to be able to proceed with that violation.
All right. So 33 days, $200 per day, $122 admin fees. Bring the property into compliance, but as we sit here, we don't know what the compliance would be without a survey that clearly identifies the shoreline protection zone. Anything I'm missing as it relates to that portion of it?
No, sir, I think that's it.
And then what would be for the garage, that would essentially, if the variance is granted, then it would resolve the code matter as it relates to that. Otherwise, it would have to remove any encroachments into the side setback.
Right. So if the variance were to decide to provide that variance for them, they would still have to go through the planning department to continue their BPR process, because right now it's still on hold, and they would still have to, abide to all the requirements, restrictions that the planning department would require. And once they get that approval, then they would have to get the building permit.
Well, I guess my question is, there was some argument that the 5 foot applies. Is it encroaching, or is it just because it was enclosed and there's no permit? Because right now all I have is permit approvals, permit requirements.
Well, a part of the approvals, those are some of the restrictions that they hold are setbacks. So I think that's the reason why they're seeking that variance, because for right now, the planning department would have to decline their application. But if they were to obtain that variance, then they can move forward with that specific issue as far as the setbacks is concerned as approval, so they could move forward and determining everything else that would be required to approve that BPR.
Okay, let me ask Mr. Bell. Mr. Bell, do you or Ms. Ward? I know she usually helps property owners. Is there a part of your variance application to deal with a setback issue, or do you?
Your Honor, the variance is about the setback, and it is what's holding up. But I would state that 30 days, whatever, how many days, is not enough to finalize if the building permit is the resolution of that, and therefore you'd be setting them up to fail. So that would not be acceptable.
Good point. Okay, thank you.
Thank you.
All right. All right, anything else, Officer Boston?
That's gonna
All
be
right.
it.
And Mr. Bell, I'll hear any last argument and any requests that you wish to make. Go ahead.
Yes, Your Honor. So we've got three main violations: failure to obtain development order, failure to obtain building permit, and removal of structures or items that are located within shoreline protection zone. I want to take them one by one. So the failure to obtain a development order. We've heard testimony today, we've seen the evidence, we've looked at the code to show that this did not require a development order for the enclosure of the garage. What we have today is something where a property owner is getting issued a citation for a violation where code enforcement didn't confirm whether or not those things had to be present in the first place. So you're getting dinged for not having a development order when you don't need one in the first place, and that's a bit of an issue. So we've already established today, development order is not needed for this project, so we ask that that first count, that citation for the lack of a development order, be dismissed. Now for the second one, for the building permit. Now our argument was that the original area that they enclosed in that garage was, but as we sit here today, we've already applied for the building permit. Obviously, we've discussed how we need to go in front of the ZBA and get a variance. Once we have that variance, we can then move forward with that building permit. All of that is conditioned on the ZBA hearing. So that one, essentially, we can put a pin in and set it off to the side. But for the third one, for the violation of the shoreline protection zone, you have property owners who are being cited for violating the shoreline protection zone, but nobody from the county can get up here today and show you where that zone is. That is also an issue. A lot of the things that they're alleging were already in that shoreline protection zone have either been confirmed to be okay by Officer Galloway, or they were told by representatives from the planning department, that's fine, those things can stay. And now, a few weeks before this hearing, we get told, hey, actually, you need to move those things. We have a bit of a government estoppel issue here, because you have one section of this government entity of the planning department with code enforcement saying, this is fine, we actually recommend you put these specific things in place, like these wooden planters with faux hedges that were confirmed by the property owner that Mr. Galloway approved. Those were put in. A few months later, code enforcement comes back and says, that's actually a violation. What you did, what we told you to do is wrong, so we're gonna assess you a violation for that. And then turn around with the fire pit. That's another, what I say in quotes, structure that the planning department is saying that needs to be removed because it's violating the shoreline protection zone. On one hand, we have a meeting with planning department. They tell us, no, that's fine, it can stay. Then we get an email back a few weeks ago saying, hey, actually that needs to be moved. It is a pile of rocks on top of gravel on top of a concrete boat ramp. I know we've had some discussion today whether or not that expands a non-conforming use, if it expands an impervious area. But at the end of the day, I asked a question to Ms. Schultz, and it was made slightly in jest, but at what point do we determine what expands something that's already in the shoreline protection zone? If you put a chair out there, are we going to get a code violation for sitting on our deck that was a non-conforming use prior to '96? If we sprinkle gravel on top of a concrete boat ramp, which predated the shoreline protection zone, are we going to get a citation for that? So in this case, it all centers on the fact that we don't know where that shoreline protection zone is, and until code enforcement has a survey showing where that is, the property owner should not be receiving a violation because we don't even know if they're in violation. So our recommendation is to dismiss at least the first and third violations for the violation of the shoreline protection zone and the violation of not obtaining a development order, and then reserving a ruling on the actual building permit issue until after the ZBA hearing.
All right, thank you, sir. All right, I'm going to close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll first address the shoreline protection zone matter. I make a finding that the county has failed to meet its burden of proof to show that there's a violation of the shoreline protection zone, or conflicting testimony and evidence related to the fire pit, as well as the being advised that the swing set has been removed already. There's evidence presented that the wooden planters were authorized by a representative of the county, Mr. Galloway. Previously, I do not find sufficient evidence to suggest that the addition of the gravel or the outlined decking is a violation at this time. I'm not saying it can't be proven at some other time, but I do find the evidence lacking today that a shoreline protection zone violation has occurred. So that'll be my finding, insufficient evidence on that particular 4.03.03. As it relates to the other two, 1.1300A, development approvals, 1.13.09C, building permit. I believe Mr. Bell has conceded the fact that the building permit requirement is subject to a variance. I do find that there is sufficient evidence from the survey to show that this is over 400 plus or minus square feet that would trigger that requirement. As it relates to the DO requirement, I don't know how I can, how it would need to marry those two, 1.1300A and 1.1309C. There's testimony related to electrical being out there. Mr. Ron testified that there's air conditioning. Mr. Baza also testified that there was evidence that he's seen related to, I believe, electrical maybe being out there. I don't know that there was any evidence related to plumbing, but I do find that I'm going to keep those two together. So I'm going to find that there is that the county has carried its burden as it relates to development approvals and building permit requirement only for the garage that is subject to the variance request coming up. Because that is part of the upcoming variance, I'm going to provide 60 days to resolve that. I would also note that if the variance is granted, sometimes those orders take a little bit of time to get issued, and then planning has to do their final review. So I'm going to give 60 days as it relates to that. Is that going to be a sufficient amount of time, you believe?
Your Honor, are we allowed to extend out to the 90-day period at least?
What's the county's comment, if anything, on that request? Would 90 days really put us, or put the county in a bind? Is there something specific that 60 versus 90 is?
I don't think we have any objection to that.
Okay. All right. So without objection from the county, I'll make the following finding that 1.1300A, 1.1309C has been proven, provide that the property must be brought in compliance as it relates to the garage within 90 days. I will honor the county's request related to if the property is not brought into compliance within 90 days. That would be August the 11th. A $200 per day fine will be imposed. There's also a $122 administrative fee. I'm going to order that needs to be paid within 30 days. That'll be paid regardless of whether the property is brought into compliance or not. Because of the finding that the county failed to carry its burden, there is no requirement for another survey or anything at this point. So I'll put that on the record. Did I miss anything, Officer Baza, related to the counties?
No, Your Honor.
Okay. Mr. Bell, do you understand anything I missed?
Not at all.
All right. Thank you both. Have a good day.
Thank you, you too.
All right. Case number CE 2400956. This is a property at 298 Smith Drive, and this is a requested fine reduction. This is a requested fine reduction?
Yes, sir.
All right. Whenever you're ready.
All right, I'm Code Officer Greg Forehand, Walton County Code Compliance. I'm here on behalf of Mr. Glenn Burkett requesting a fine reduction of his property at 298 Smith Drive in Santa Rosa Beach, case number 2400956. The initial hearing was held on 5/14 of 2025. A determination was made given until 8/12 of 2025 for the property to gain compliance through development approvals or potential restoration. Otherwise, fines of $150 a day would accrue until found in compliance. On 8/13 of 2025, an inspection was performed with an affidavit of noncompliance recorded with the clerk's office to continue the fines. And after attempts at Mr. Burkett seeking approval through planning for the prior development plans, the owner did decide not to move forward with any development, requesting an environmental inspection for any need of restoration. And on April 2nd of 2026, environmental planner, Mr. Brad Bond, made a determination that there was an adequate canopy cover remaining and other vegetation is growing back naturally, not requiring restoration. And that determination brings the property into compliance, and an affidavit of compliance was recorded, stopping fines as of 4/2/2026, totaling $34,800.
So this was if I recall, and trying to refresh my memory, this was partial clearing of the property.
I believe the initial intent was he had acquired someone to do some mild clearing for survey purposes, and they went beyond the boundary of what they should have for the intent of surveying, and it was stopped and put a stop work order on it before it went any farther.
Okay. And then what was the issue with, you said he was attempting to get approval through planning?
I think he had a couple of proposed developments he was going to potentially seek, and for the zoning in the area, and he was going, I think he was going to try to get a possible rezoning, and that didn't work out. But he does have an actual residence that's attached to the acreage there, and so in falling back on that in the end, he has decided not to go through with any development. And but there is a residence attached to the acreage here at the lot, and so he spoke with Stephen Schoen, I believe, and with this determination and then potential maintenance of the continued property being there is a residence attached to it.
All right. Mr. Burkett, so we have $34,800 in accumulated fines. You're requesting a fine reduction.
Can I introduce myself? Yeah. I'm not Mr. Burkett.
I'm sorry.
I'm sorry. That's okay. I'm representing the owner. My name is David Forstrom. I'm a licensed professional civil engineer.
Okay.
I do 3 to 5 large developments per year in Walton County. That's where pretty much all my business is. I met Mr. Burkett because we had a development on Chat Holly where we had to have a neighbor meeting. He was across the street. So, he asked me, he goes, David, I need help. This has been going on. I don't know what's going on. I'm just, clearance on my property. Can you please help me? So I offered to assist him to kind of navigate through the process. And I think where things went wrong, and I will say code enforcement, everybody's been very helpful in kind of clearing things up. I think the guy who was doing the clearing said, oh, we're going to do a boat RV storage or whatever, when really the clearing was the intent was for wetland delineation. And they did take out some brush and stuff like that, but it's really his front yard. I mean, he's got a large property on the bay. He was doing, lawn maintenance in his front yard, basically. So I offered to assist him, and Mr. Burkett had repeatedly tried to solve the problem. He'd gone multiple times here, said, can I get a land clearing permit? He didn't realize they don't allow them south of the bay. You have to get a development order. But he was never to the point of getting a development order or doing development. He was just in the rezoning process. So, and basically he cleared some property on his land. So I kind of muddled through and figured out what was going on. I said, well, what's the fix? If you have a code violation, you have to fix it. Well, the fix was to get a land restoration plan. So that's when I reached out to Bradley Bond, the environmental planner, who's very responsive and very helpful. He came out there and said, David, there's no land restoration required. There's no endangered species, just the grass is growing back. So my position was there never was a code violation, because if there's nothing that needs to be fixed, you don't have a code violation. So I feel like Mr. Burkhead did everything in his power to try to solve it. He just was not, experienced with the county process as I am, and I can understand that. And so I would request total fine reduction since there never was a code violation.
All right,
That'd be my request, yes.
understood. All right, Mr. Forehand, what's the county's position? Is it Forstrom?
Forstrom, yes.
Yeah.
Forstrom, yes.
Mr. Forstrom's request on behalf of the property owner, Mr. Burkett, to reduce this to zero. Does the county have a position one way or the other?
I mean, that was a lot of time, and with us going to previous hearings and the inspections and time, I feel like something should be considered for, a reduction potentially, yes, but not a full to nothing, with the investment of time and paperwork and inspections and so on and so forth, because the initial intent was for development. Is the reason it was deemed as a violation of the clearing without permits.
Okay. Right. I think I recall this because there was mention of, were you involved in any part of that, Mr. Forstrom, related to an alleged RV?
I was not. I met him in December after all this had transpired, and he said, "Oh, David, I'm trying to get rezoned for RV boat storage." I told Glenn, I said, "Glenn, that's not going to fly. That rezoning would not be approved." So I was trying to give him some advice that it was probably not a good idea to start with that anyway. But I was not involved in any of that development whatsoever. I just met him in December, and I was trying to help him out, wade through the process, because like based on the last case you had, it can be kind of convoluted. You get different answers from different people. Doesn't mean anybody's bad or wrong. It's just, they don't understand all the details. And I just got down the dirt and understood it and reached out to Bradley, and that was the key, getting an environmental planner to look at it and say, no restoration is required. So there was no fix required, which again, in my mind, means there was never a violation. And, I'm sympathetic to the county having spent, time on this, but there was never a violation. There's no restoration required. And it is his primary home. He was.
Understood. Good points. All right. Mr. Forehand, anything additional before we close this out?
Well, yeah, well, on our side of things, though, it was presented in the past and adjudicated as, a clearing violation and deemed as a violation at that time, given the circumstance it was. Even though circumstances have changed in the end, with a change of mind and not pursuing development and a change.
I think a lot of the confusion was they were not aware this was his primary residence. I'm not saying they weren't, but they thought it was just a vacant piece of land. I agree, vacant piece of land, you start clearing, you have to have a development order, is permission to clear. This was actually his primary residence, and so, and again, in my opinion, there was no code violation, and Glenn, Mr. Burkett, talking to him, he's an honest, good guy, did everything to figure out, what can I do, what can I do, can I get a permit, can I do this? He even asked me today, he said, well, I had a limb fall down because of a storm, do I need to get the county to look at that before I take the limb off? So, to me, it's yard work, basically, and clearing for a surveyor. And again, there was never a violation to fix, and it wasn't determined that until the environmental planner said no restoration is required. So just because someone talks about plans, I may be rezoning this, they hadn't even taken the first step for doing any development activity. They haven't even had a pre-app meeting on it. They were just it was a maybe. And I think there was an honest misunderstanding on the part of the county, and I don't think it's anybody's fault. So it's kind of my summary, yes.
No. All right. Anything else from the county?
Well, a year prior to this happening, there was a meeting and a plan before that, a discussing of some type of complex to go there, and it was I don't remember if it was denied or something of that nature, and then this happened after that, and then for the second proposal to come through.
Okay. All right, thank you both. All right, I'll close the evidence portion. Oh, I'm sorry. Yeah, who are you?
Thank you. My name is Barbara Morano. I'm a board member of South Walton Community Council. I've been involved with this initially when Mr. Burkett wanted to do the rezoning. So it went far beyond the pre-application process. There was a technical review committee. So Mr. Burkett was very aware of process and procedures. And he had a different engineer at the time, Dean Burgess. Now, we took a stand, and the neighborhood took a stand against the rezoning, and I know that's not the issue at this point, but there was a code violation. And all of a sudden, Mr. Burkett withdrew his application from the planning department to stop the rezoning. So when I wanted to find out what the code violation was, and it was because he cleared the property in anticipation of his RV storage, boat storage rezoning. It was a clear-cut situation. I went down and I looked at it. Why the county, I don't know when that restoration plan was given to him, but this all started 2 years ago, Your Honor. Why are we standing here and he's saying, oh, whoa, I'm so sorry, this didn't happen, and then planning now comes after 2 years. Of course you have vegetation. So if you're going to reduce the fine, I can understand that, but to completely wipe it away, took 2 years to get here. Why didn't he complain from the very beginning that this was his home and single family? And quite honestly, I asked if it really was his home because he lives in Panama City. So I made a code complaint saying, does this man really homestead here? And code could not go on that property because there were no trespassing signs. So they didn't even go to the door, they didn't ring the bell, they didn't do anything, and I understand that's what they can't go if there's no trespassing. So the county appraiser told me this is the only homestead he has, so therefore he's homestead. Well, logically, you could have 2 homes, you can live in Panama City, you can still homestead in Santa Rosa Beach, you can have a no trespassing sign, and everything is still legal. I'm not going to argue that. That appears to be what it is. Can't prove that he is, can't prove that he isn't. But now to say, oh, woe is me, why didn't that happen 2 years ago and get all this wiped off the book? And I guess my question for planning is, when did they give him the restoration plan? I was not sure. May I ask that question?
I mean, I think you can ask it offline. I'm not going to make them answer it right now.
Well, did they even have a restoration plan?
Well, I think the testimony's been that there's no restoration plan required, that they've visited the property, and that due to the current growth that's on the property, it's somewhat remediated itself.
Well, to me, that sounds like if you have a code complaint that you're cleared the lot, then you should have a restoration plan 2 years ago. Why was it even left like this? That's an issue for planning and to talk about.
Understood. Anything else, Ms. Morano?
Well, this shows anybody could clear a cut of land and not worry about restoration and come here and get their fines reduced. And that concerns me overall for Walton County. So thank you.
Yes, ma'am. All right. Mr. Forstrom, I'll let you have one last word.
Pretty much everything she says incorrect, twisting the facts. The reason the project was stopped is I met him 3 months ago. He went to the meetings on the rezoning, and it was clear the county was not going to approve this rezoning for storage. So he never got to the point of even having a pre-app meeting for a development. He wouldn't do that until the rezoning is approved. So his stopping the rezoning had nothing to do with the code enforcement violation at all. And like I said, that's not true.
All right. Thank you, sir.
Sure.
All right. Anyone else from the public? Anything from the county? Anything additional?
Just the administrative fees are $50 for that.
Okay. Were the previous administrative fees paid?
Everything's covered, yes, sir.
Okay. All right, thank you.
Ask one more question.
Yes, last one.
Is there a limit on how much you can clear your yard for your home before you get a code violation? Is there
We're not gonna relitigate the case,
I got you.
so that's not what we're here for today. All right, anything else?
No, sir.
All right, thanks. All right, I'm going to close the evidence portion of this hearing. I do make the finding that the application for a fine reduction is well received. I believe Mr. Forstrom brings up some good points, but I also believe Ms. Morano brought up some good points. It appears, based on what I recall, as well as what was said here today, that Mr. Burkett was in the process of trying to get his property rezoned, and in doing so, maybe he got a little ambitious and began clearing. So I will not do as Mr. Forstrom requests on behalf of Mr. Burkett to reduce the fine to 0. The county didn't provide a proposed fine reduction, so based on my own review, I will agree at this time and order a fine reduction to, make sure I got this correct. We have accumulated fines of $34,800, that the fine will be reduced to $3,500. Mr. Burkett will need to pay that fine, the reduced fine. Let me add, there's $50, so it'd be $3,500 for the fine to be reduced to, and a $50 administrative fee, for a total of $3,550. Those amounts will need to be paid within, can Mr. Burkett make that payment within 30 days, or will he need more time? 30 days? Okay. You'll need to make that payment within 30 days. Do be aware that if the reduced fine amount as well as the administrative fees are not paid within the 30 days, that the original accumulated fine of $34,800 will be reimposed automatically. Are there any questions regarding the fine reduction or the order? None? All right. Thank you all.
Thank you.
Just give that a couple days for them to get that into the system, and then you can pay that. All right, our next case is 25-01092. Property address is 68 Sherwood Road in Defeniak Springs, and this is also a fine reduction request. And this is related to the Arlene Blevins estate of Arlene?
Yeah.
Okay. And who are you, sir?
My name is Jim Robb. My daughter is listed as the owner, but it's a ladybird deed, so I'll be the one that's really be there.
Oh, okay, so you're the heir to get the property?
Yes, yes,
All
yes.
right.
Oh, I turned it off. I'm sorry.
Turn yourself back on. Go
No,
ahead.
never mind. Hold on.
Just want to state that this property, at the time of the violation, was under the estate of June Arlene Blevins.
Okay.
It is no longer under that property owner. It is now under the new property owners of Shannon Lee Woodard and Christopher Aaron Krivick.
Okay. When did that occur?
If I can explain the circumstances. I moved here from Texas back in October looking for property. I moved here because my ex-wife has last stage Alzheimer's, and I was trying to support my son and my daughter that are here. And I looked everywhere, found this 3 blocks from where my little travel trailer was parked at a Sapphire place there. It looked abandoned to me. It was not for sale. So I'm not really computer literate, I asked my son to find out who is the owner. He found out that the person that's the executor of it is a man named Chris. He's incarcerated since November, and it had never been probated. She died in 2017. It went 2 years past, never was. So he agreed, and his sister agreed, who were heirs to the estate, to sell the property. And so the first thing that I did, I went to an attorney in Defuniak, and I had to pay $1,600 to get it probated. And then after it got probated, there were code violations. And so what I did is spend almost $6,000 even before I had title to the property. He was put incarcerated in November. It was a $150 a day fine. And so when I inquired about the property, the fines were $25,000. And so I wanted them to stop. So I went and, when they both agreed that they would a certain price and that I could buy the property, I went and leased a Bobcat for a week and got 2 30-yard dumpsters, and I filled them all up and cleaned it up. And then it was, I originally saw the property March the 6th. We closed on, I think, the last day of April. It's in my daughter's name, Lady Bird deed. But I had cleared the property about 2 weeks before that. And like I say, all the trash was off of it, fences off of it, 2 30-yard dumpsters cut down a 3.5 foot in diameter dead pine tree, but it's all cleaned up. And I would like to say this. The reason I'm even doing this and giving the circumstances, the law doesn't tell me to do this, but I've been paying $2,000 a month for quite a long period of time for my ex-wife's maintenance. She has Alzheimer's. I do appreciate Florida. Florida provides about $16 an hour to look after her during the day, but nobody comes to your house for $16 an hour. So I told my daughter, I said, look, if you get some ladies in your congregation there that come, so they come during the week. I pay the difference between Florida and pay them $200 a day. All they do is sit there from 8 to 5. And then at nighttime, my son has to watch my ex-wife, and my daughter's out of town for business, has to watch him. And then sometimes when there's nobody there, I have to pay $200 a night for somebody. I don't have deep pockets. Everything that I have is, I'm getting money on the sale of my house in Texas for the next 4 years, but I'm not trying to not pay anything. I understand a lady here mentioned that I need to tell you how much I can pay. I would appreciate forbearance on the court. Like I say, I'm not trying to get by with not paying anything, but the least that I could pay wouldn't hurt my feelings. I'm going to be 78 years old tomorrow. I don't have an oil well, but I want to pay something. But like I say, I would leave it in your discretion if we can reduce it as much as we can.
Understood. So the accumulated fine appears to be $28,500. There was a $73 administrative fee, and maybe another $23 administrative fee as well. I'm assuming none of the administrative fees were paid either if the gentleman who was part owner was in custody?
No, I think you did pay for the administrative fees. He paid for the administrative fees.
I don't know if I did or not. A title company there in the Funiac, they paid the taxes there were back taxes on it. But like I say, I'm asking for whatever leniency that you can give me, because my money is paid to my ex-wife, because the law doesn't tell me to do that, but she had my 3 kids, and so.
Understood.
Yeah, the fees, the previous fees have been paid for. There is a $50 administrative fee for the fine reduction.
For today, but
If I would just say it would be pushing it, my budget extremely limited, because like I say, I'm paying that for a long time, $2,000 a month. That comes straight out of my savings.
yes, sir.
And if I could pay $1,500, $2,000, that would, like I say, I'm not going to go on a vacation with the other money. It's just strictly.
Yes, sir. No, I'm just trying to get a handle on what all loose ends are hanging out there that we need to address.
I have a deed here it's a warranty deed. It says April the 30th. Yes, so it's signed over in a Lady Bird deed. Lady Bird
The, hold on a second, Officer Baza, the draft order I have in front of me shows,
Do you want a copy of this deed?
no, sir, I don't need that.
Is it all right if I approach?
Yeah, come up here for a second. The amount that you have listed is different than the amount on the compliance affidavit that was signed. So here's the affidavit of compliance listing 28.5 as the accumulated fines.
Yeah, I see it.
And then this one here looks like it has an August 13th, 2025 date. So that would be need to be corrected as well on page 1. I think that was when the original hearing was. But that should be today's date, right? So if you want to take that and make notes on it, on what needs to be corrected, and then I'm gonna go ahead and
That'll just be today's date.
correct.
Can I just mark that up?
Well, I thought you're gonna have to fix the,
Okay, we'll just do a,
yeah, just do a new one. But I'm gonna go ahead and
Okay.
go ahead and take care of this today.
Okay.
All right. Mr. Rob, no, I think I've heard enough. Is the county got a position as it relates to the request? And does it object to the fine reduction request? Or does it have or does it have an amount that it would request regarding the fine reduction?
no, sir, no,
I'm just,
No
I don't,
recommendation.
Hold on, Mr. Rob.
I'm sorry.
Go ahead.
no recommendation and no objection.
Okay, so no objection to the request, to the fine reduction. The property's been brought into compliance. Sounds like Mr. Rob has spent some money to clean up the property and has purchased the property. I understand, as you said, you're not trying to get away from all of it, so I appreciate that part. Understanding that the accumulated fine is $28,500, and there's going to be a $50 administrative fee. Do you have any final comments, Mr. Rob, related to the fine? What you would look for? Otherwise, you just
It
wanna
would
leave
help
to
me if the fine could be reduced to $2,000.
All right.
As I say that, I'm not on the side of the street with a sign will work for food, but
Right.
everything is going right now to my ex-wife for take care of her.
All right. Understood, sir. Thank you. All right. Anything else from the county?
No, sir.
All right. I'll close the evidence portion of this hearing based on the testimony and evidence and no objection by the county. I will find that a fine reduction is appropriate in this case. The fine amount of $28,500 will be reduced to $2,500. Mr. Rob, would that, could you pay that within 30 days? Or
Yes.
would you need a
yeah.
little more time?
No, I'll pay it in 30 days.
Okay.
But I appreciate it. I do appreciate Florida they pay for people that my ex-wife's situation. They pay $16 now, but you can't get somebody to come to your house for
Oh, I know.
16. And so,
Understood.
they sit there from 8 to 5. They don't cook and they don't clean, and all they do is make sure she doesn't hurt herself or she knows where she is,
Correct. No, I understand. I'm going to give, as I said, the fine will be reduced from $28,500 to $2,500. I'm going to go ahead and just give you 45 days, just a little bit of a cushion there. And there is a $50 administrative fee that will also need to be paid. I'll order that needs to be paid in that same 45-day period. And you'll need to wait a day or two, let the county
Sure.
get that in there.
I sure appreciate your deference.
Yes, sir. And we appreciate what you're doing. And so that'll be the order. What, anything else from the county? So just be aware, June 27th. And there were some issues with the order, so Officer Boz is going to get that fixed. I'll sign that either later
Thank you.
today or in the next day or two. And then just call them and they can coordinate with you.
I
on
sure
where you get
appreciate
the
it.
payment.
Okay,
Yes,
so
sir.
who do I pay the money to?
Just
Who-
contact code enforcement at
Code
their number
enforcement,
and they'll
okay.
direct you on where to go.
I have to say, off the record, Miss Jenna has really helped me.
Well,
She's
good.
got a good bedside manner, and so I don't go ballistic.
Well, we appreciate that. So, all right, Mr. Rob, good luck to you.
Thank
and
you.
that
I am.
concludes your
Thank you.
case.
Have a good one.
All right, we've been going for a little while. Do we want to just keep pressing forward? Yeah, all right. Case number CE 2302-747. This is number 5 on our agenda, S&R Land Investment LLC, fine reduction request. And who do we have for S&R Investment? What's your name, sir?
Ryan Troop.
I'm sorry, Ryan what?
Ryan Troop, T-R-O-U-P.
Okay. Right. Let me do this. So I have a copy of the order requiring the property be brought into compliance on or before August 13th of 2024. Affidavit of compliance showing the property was brought into compliance on February 19th, 2025. Is that right? 2025? It was brought into compliance? Okay. And then, so we're dealing with a requested fine reduction today. All right, Ms. Hicks, anything else to add? Well, this was a restoration issue?
Yes, sir. It was a restoration that was required for the property that was cleared without a permit. A restoration was completed and is now in compliance. It was out of compliance for 190 days. We asked that we have no objection to a fine reduction. However, you do order that the $50 administration fee would be paid and that the county's recommendation is that the reduced fine be paid within a specified time frame, otherwise be reinstated to the original amount.
And I have, is it 38,000? Is that
Yes,
sound
sir.
correct? Okay, so the accumulated fine of 38,000 and county's not objecting to fine reduction. They don't have a specific amount. I'll hear from you, Mr. Trobe, on what you want me to hear.
Okay, so bear with me. I'm just going to read some timeline here. And I'm very dyslexic, so it's going to take me a second. I apologize, but I respect your time. So we first received from Bradley, who was just here, on April 10th of 2024, that what the restoration plan was going to be. On April 19th, I sent him the wetland study, the original one, which was done in 2022, July of 2022. So it was less than 2 years old. Excuse me. I contacted Alicia Kuhn, who was the landscape architect, and on May 16th of 2024, the deadline was set for August 13th to have the restoration plan completed. On August 8th, I submitted that restoration plan 5 days before it took Alicia a little while to put that together. Took Alicia to put that together. I submitted on the 8th, which was 5 days before the deadline. And at that time, Bradley looked at the wetland study, which he said was not valid because it was more than 1 year old. Alicia and I could not find anywhere that said a wetland study that was more than 1 year, less than 3 years old was a problem. So that's why I didn't get a new one done. At that point, we decided to get a new one done because he told us we needed a new one. So it took, and that was on the 8th of August. That took until September 19th was when we finally got that one completed. And then we had a new wetlands, with that new wetland study on October 1st, we had the new plan put together and submitted it on the 9th. The new restoration plan, Bradley, I checked on it on the 4th, and I have emails from all of this too. I checked with him on the 4th to see if he had looked at it, and he hadn't. I checked it with him again on the 9th, and he didn't get back from me until October 24th. No, I take that back. I still got no reply on October 24th. These are all different emails to Bradley to see if he could get that given to us. It wasn't until November 7th of 2024 that we finally received an approved restoration plan. And within 90 days, I submitted for that plan to be inspected, and that was February 5th. So we submitted it. We checked in with him on the 17th to make sure, or I'm sorry, on the 5th, and he replied right away. He said, it's in my docket. I'll get to it as soon as I can. It's in queue, basically. I'll get to it next week is what he said in the email. And that was on the 17th when he replied to us. It was on the 19th that we finally received notice that the property had been looked at and was in compliance. So basically, it kind of all boils down to when I submitted the initial stormwater drainage plan, not stormwater drainage plan, the wetland study back on the 19th, if I had known then that it wasn't adequate and that less than 2 years is not good enough, I could have at least started that process. But that took a couple months, then it took a couple months to get the new stormwater drainage plan. Then it took me less than 90 days, but close to it, to get that stormwater drainage plan completed. So, long story short, the timeline does look like it was a long time, but I worked as quickly as I could, and I have a bunch of emails, texting, or emailing, can we get this looked at? I really want to get this behind me. And it just kind of lingered. So that's where we are.
All right. What would you be requesting since it's your request? Do you
Well,
have a?
Well, I see, and this is something that maybe it went to my junk mail, but looking at the paperwork that I have was given today, I see that there was a $6,000 fine, and that was recorded in, I think, like October 12th, because I wasn't in compliance, but that wouldn't have been until October 13th. Neither here nor there. I request that it be reduced to $6,000 and plus the administrative fees.
I think what you're looking at, I see it in the packet. It's looks like it was filed September 12th.
Okay, September 12th, okay.
2020.
So a month after the deadline.
Which is that's common practice for the county to get those out. So, so your request is to reduce the total fine amount to coincide with the prior order imposing fine and administrative lien of $6,000 that was filed on September 12th of 2024.
Yes, Your Honor.
All right.
Even though if we had just had that wetland study looked at when I first sent it, this might have all been taken care of within the allotted time.
Yeah, and I can recognize, I mean, some things are just out of your control, right?
And planning's super busy. I recognize that.
No, understood. All right, anything from the county? All right, thank you both. I'll close the evidence portion based on the testimony and evidence and no objection by the county. I will find there's sufficient evidence to regarding the fine reduction request in order that a fine reduction is appropriate in this case. Based on Mr. Trobe's request and nothing by the county, I will order that the $38,000 fine be reduced to $6,000. There is a $50 administrative fee that will also be imposed, so it'd be $6,050 total. Mr. Trobe, could you pay that within 30, or will you need a little more time?
I'll take care of it in 30 days. I have a card.
Do understand, as I've told others, if you fail to pay both the reduced fine as well as the administrative fee within that period of time, the original accumulated fine amount of $38,000 will be reimposed. So just be aware of that. That's why I always ask if people have any issues or believe they might, so we don't set you up to potentially fail. So, all right. So I've signed that order. Give it a couple days and then get with code enforcement on how to get payment. But so your fine's been reduced to $6,000, and then there's that $50 administrative fee.
Thank you very
All right,
much.
thank you, sir. Have a good day. All right, our next case is CE 23-02-447. This is also a fine reduction. This is property owner Christy Coble, C-O-B-L-E, and the property address is off of East Point, Washington Road. Are you Miss Coble?
I am her mother. She is teaching school today, so I'm going to represent her. When my daughter was born...
I'm sorry, hold on. So you're here on behalf of Miss Coble. What's your name?
Amy Wise-Coble.
Amy Coble. All right. Thank you, ma'am. Go ahead.
Okay. So basically, she is a teacher and the head basketball coach at South Walton. She inherited bank stock that was purchased by my parents and my ex-husband's parents when she was born. She made an arrangement with her dad to swap that bank stock for 2 lots in Point Washington. The code enforcement case we were aware of. I'm certainly not denying that. But I do have, as I think the prior person said, a couple of emails to planning, I don't want to call names, where literally they are entitled HELP, H-E-L-P. We don't know what the issues are. We don't know how to resolve them. So those went in October. Fast forward, basketball season's about to start. Basketball season started, and we came home, I think it was in January. She came home. She was at the time living in a first floor apartment in my home. And she said, "Hey, Mom, I've got this notice from the county. And what is this?" And I said, "You got to go to this letter. You got to go pick it up." And we were already being told that we had skipped a hearing that we knew absolutely nothing about, and that we were going to be start being fined $200 a day in March. So of course, as soon as I got that, I was like, oh my God, we got busy, but there was absolutely, we've moved as quickly as we possibly could. I do want to say Georgina has been fantastic. I think the original guy on this case maybe retired during it, so he was one of the people that I was reaching out to, asking for help and understanding of what we even needed to do. And so, I'm just here to say that I don't think this has been treated, that she was treated fairly, because she's a rule follower. She was never noticed of the hearing that we supposedly skipped. We would have run here because we were so searching for information to be at a hearing where somebody could tell us what we needed to do. So I guess, I don't know if you have any other questions. I have some emails here too, but one of the things that was noted is they did post the property, which is, they did post this on the property, which is a legal way of noticing her, but she deserved to be made aware of the violation. As you see, they simply whited out her info and the date and dropped it in the mail. So something happened with that notice of the first hearing we were supposed to have been made aware of. I don't know what that was, but again, we've resolved the matter from there. We've been through the DEP. We've spent thousands. I did meet with, one time with planning with a mitigation plan. That was when we learned that we had a DEP issue, so we had to hire consultants. And I've explained to her, she's quickly devaluing the value of the lots and the fact that she swapped something so valuable for them. But I'm here to ask for any consideration you will give her.
All right, thank you, ma'am. Anything from the county? I see that the accumulated fines appear to be $77,400 is what I have on the affidavit of compliance.
Yes, sir, that's correct. For a noncompliance of 387 days, the county doesn't have an objection to a fine reduction. The only thing we ask is that you do order a $50 administration fee for the orders that are in the county's fees that would, recording the orders. Property, like like I said, is in compliance and we don't have an objection, we do ask that you, if you reduce the fine today, that it will be paid within the specified time frame. Otherwise, be reinstated to the original fine.
Understood. Remind me, the original order that was issued found a violation of a clearing permit, so were these properties partially cleared? And was it like the last gentleman where they needed a restoration plan, or they had to get a permit and neither one was applied for?
That's correct. They were cleared without a permit, but they have now received permits or development orders for single-family residents on the lots.
Okay. And you may or may not know, is the intent to build on those lots now, or did y'all do it?
Correct.
Oh, okay.
After we realized that mitigation was not the route to go, especially going through the DEP, we've now had 2 single-family homes designed. She's living in Freeport now. Originally, she was going to build on one of them, so it's just been a long road, but that is what we intend to do.
And I know you're just a representative for Miss Coble, or Christy Coble Wise?
I know, my last name's hyphenated. I'm Wise hyphen Coble.
Okay.
She's Coble.
Okay, my mistake. So, as I've done for everybody, I mean, is there a particular amount that you had in mind that you want me to consider, or do you just want to leave that up to my discretion?
I mean, she's a 26-year-old school teacher, so whatever we do, I'll have to pay, and she'll have to pay me back over time. So I assume I'll just leave that up to your discretion.
All right, thank you, ma'am. Anything else from the county before I close the evidence portion of this?
No, sir.
All right, thank you. Thank you both. I'll go ahead and close the evidence portion of this hearing. Based on the testimony and evidence presented, I do find that the application for a fine reduction is well received, and will order that a fine reduction of the $77,400. I will, at this time, order that the fine be reduced to $3,500. Would whether it's you, Miss, or your daughter, Miss Coble, or Miss Coble Wise?
Trust me, it confuses people all the time.
right,
Nothing offends me. You can call me either.
What about, how much time do you believe you would need to pay the $3,500, or she would need to pay the $3,500?
45 days, please.
I think that's reasonable. So I'll reduce the fine from $77,400 to $3,500.
Thank you very much.
The 45 days in which to pay. And there is a $50 administrative fee, so the total amount will be $3,550. Both the administrative fee as well as the reduced fine will need to be paid within the 45 days. Should they not be paid within the 45 days, the original amount of $77,400 in accumulated fines will be automatically reimposed. You have any questions regarding that?
No, sir. Thank you very much.
All right. Best of luck to you. All right. Our next case is going to be CE 23-01739, Delta Bella Vista House. And this is also a fine reduction request. All right.
Your Honor, William Ketcherson on behalf of Della Bella Vista, and then also I have a representative of Della Bella Vista
right.
present, and the representative of ECM Engineering, John Green.
Okay.
And would you like me to have them come forward to this table just for ease?
Yeah, that's fine. And then let me just see what the accumulated fine is. And then
$109,000.
109, okay. And then I'll go ahead. I'll go ahead and let Mr. Kitcherson begin, unless the county wants. Okay, go ahead.
So, Your Honor, thank you. We are here requesting a reduction, and this does seem like, am I too loud with this thing in my face? A lengthy case, because it does originate to an original 2023 violation. But I do have, as I said, the representative of Della Bella Vista and Mr. John Green of ECM here because ECM was retained back in March of '23 to help resolve these issues. And there was a restoration plan submitted in August of '23, and then a new survey was required in September of '23. And I just want to be clear, Your Honor, I'm just trying to give you a timeline, and then I can offer testimony to substantiate that timeline. And then in November of '23, a new BPR for stormwater review was submitted. And then in February of '24, a stormwater and restoration plan number 2 was submitted. And then in July of '24, a request for relief from the scenic barrier buff, which I believe was the original problem here, was the scenic barrier area and the encroachment of, I'm going to use the term terrace, but it's also been called a gazebo. And then the removal of some trees. And then after that request was denied in October of '24. And then in January of '25, a new plan was resubmitted. And then in February of '25, there was an additional landscaping and restoration submittal. And then the plans were finally approved in January of '26. So while it has been pretty much a 3-year-long process, the client has been actively engaged in trying to remediate these problems. Also, during this process, Ms. Neiman, in her review of the subject property, discovered a couple other problems that predated my client's ownership, a pool and a roof, but those issues have also been brought into compliance as evidenced by the affidavit of compliance. So we are here asking for a substantial fine reduction because my client will testify that he's expended about $70,000 in bringing this property back into compliance through labor and trees and moving the terrace or gazebo and the resubmission of the restoration plans and stormwater plans. And that's it in a nutshell, other than testimony.
All right, well, let me ask the county, do you dispute any of the summary that Mr. Ketchers had provided regarding plan submissions?
I believe there was only one submission for a restoration. I think that there was additional documents that were required for that same submission, just extra documents that were needing to be required. But I do, if I'm recalling correctly, that restoration plan has been approved for at least a year, and he waited a year to implement. Once he did start to implement, he did get everything done within a few weeks to get that the landscape buffers, the 30A scenic corridor buffer, all of those things out of the side setbacks and the corridor, all of the items that were in that area. He did get all of those things done very quickly, but he did take quite a while to put that in action after approval.
So it was the approved plan, was that the January 26th plan, or was this an earlier plan?
I do not have that date in front of me.
You said it was a year before he actually started, the plan was approved a year before.
Give me just one moment, I'm sorry.
Or, if Mr. Ketchers has it, I'm just trying to.
And I have Mr. Green here. He could he could testify. So could Luciano. But I believe the plan approval was the final plan approval was January of '26.
And I'm recalling January of '25.
Okay. Well, I'll allow him to present.
I don't have that date in front of me either way. So
for what it's worth, we had to resubmit.
And I'm not gonna.
No.
And I'm not gonna try to prevent Mr.
I don't have it in here in front of me, so I feel when reviewing this case and reopening the second case that we had at that time, I remember specifically having to go and ask Brad Bone if he would have to resubmit for another restoration plan because the current one that had been approved was expired. And he said that he did not. So we used the same restoration plan in March that they implemented even though it had expired within those 90 days. And we did not make him resubmit the same plan over again and repay those fees.
So if it was approved, well, that would seem to track his timeline then. If it was approved in 26 and expired in March, that's 90 days. And
No,
then-
it had expired over a year.
Oh, over a year, okay.
I've got that it doesn't exactly track, but it is close. I've got that we submitted in February of 25.
And
And that's fine.
I'm not going to dispute. I honestly don't know.
What I was trying to do is just, I mean, if there are, points of contention, so to speak, then I'll allow Mr. Ketcherson to go ahead and put on any testimony. I was just trying to short circuit some of that, because if everybody's in agreement, stipulated, then we'll just kind of go to
We're
the
not
meat of it.
opposed to a fine reduction
Yeah.
at this point.
Understood. Well, let's do that. Well, I mean, obviously, it took some time for it to get here. What is your client, Delta Bella Vista House? And again, if you want to present testimony and evidence, if you think that's helpful for me, I'll be glad to hear it.
No,
I'm just trying to short
keep going.
circuit. I know
Yeah,
you've been
keep-
here a
no,
while,
keep
so.
going.
Where would you like to land?
We would request a reduction down to 10% of the 109,000, which I believe, if my math is correct, and I'm certainly not an accountant, that would be 10,900 plus all administrative fees. And the previous ones were already paid.
Okay. Does the county have any issues or comments, other recommendations beyond what Mr. Ketcher said, client? Okay. All right. Anything else either party wants me to consider?
No, sir.
All right. At this time, I'll close the evidence portion of this hearing. I'll make the following finding that based on the evidence presented and no objection from the county, that a fine reduction is appropriate in this case. I'll order that the accumulated fine of $109,000 will be reduced to 10%, which would be $10,900. There is a $50 administrative fee that will also be in addition to the $10,900 reduced fine. Would 30 days, or does your client need more time?
30 days is adequate.
Okay, so I'll order that the reduced fine as well as the $50 administrative fee will need to be paid within 30 days. In the event the reduced fine is not paid within 30 days, as well as the administrative fee, which will also be paid in 30 days, that the original amount of $109,000 in accumulated fines will be reinstated. All right, any questions regarding the reduced fine order?
No questions. Thank you,
All
Your
right,
Honor.
thank you. All right, have a good day. All right. The next case we have is CE 25-01662. Property owner is listed as Miles Golding, and this is also a fine reduction. Is someone here on behalf of Mr.? Oh, okay.
Yes, good day, sir.
Hey, how
My
are
name is
you?
Shiraz Hossein, and I'm here on behalf of Mr. Golding, and Mr. Golding is present.
All right. All right, and we'll try to do this one as well. Let me see what the accumulated fine is. We have accumulated fines of $37,500. Fine started December 12th, 2025. Date of compliance is listed as May 11th of 2026. The daily fine was $250, and appears the original violations were development approvals and building permit requirements. All right, we're here on a fine reduction. Appears property has been brought into compliance. Be glad to hear any mitigating factors or whatever the county, or I'll let you go first, Mr. Hussein, if you want.
Yes, sir, Your Honor. We're here on the fine request here on this matter. a lot of this, and it's not worth it at this point to go into it, but unfortunately, because of travel, Mr. Golding was not able to be present at the hearing that resulted in the order being entered. But, you know, prior to getting that done, he had had a wetland study completed, he had his septic permit approved prior to that, to the hearing. There was nothing bothered with wetlands on the property. Mr. Golding was very active with the county building and planning department. Once he realized what was going on here, he thought he had it resolved, and so he took immediate steps to resolve the matter. He's you know, if testimony is necessary, he's spent several $1,000s to get everything completed. You know, was very appreciative of working with Miss Rachel, Mr. Bryan, the others in the county planning department, and Mr. Golding is requesting that the fines be reduced to $2,000 plus the administrative $50 fee. The previous, the county can discuss that, but the previous administrative fees have already been paid. And $30, 30 days is more than reasonable to pay the amount. We just ask that also that once the fees be paid, that there would be, because the matters resulted in liens on the Highway 20 subject property as well as another property on Fluffy, and so that once the fine is paid, that there be a satisfaction or whatever the procedure is to have those lien removed off of his property.
Yeah, I think by operation of law, whenever you file the fine orders, they attach to all properties within the county, so even the ones that aren't under any code issues or violations. So I don't know what the procedure is or how quickly they file fine reductions or satisfactions. You'll probably have to get with the county attorney or code on how quickly that can be done if Mr. Golding's, you know, attempting to sell or do something with that other property or any of his properties. So, all right, so I have on my notes, Mr. Golding is requesting the fine be reduced to $2,000, 30 days to pay, and not an issue if they're regarding the $50 administrative fee. What's the county's position, if any?
We don't object to a reduction, but we're going to leave it up to your discretion on the amount that is owed.
Okay. All right. Anything else from either? All right.
No, Your Honor.
All right, thank you. I'll close the evidence portion of this hearing. Based on the evidence presented and no objection from the county, I'll order that a fine reduction is appropriate in this case. I'll order that the fine amount of $37,500 will be reduced. I understand Mr. Golding's request of $2,000, but I'm going to make that $3,000. Would that still hold true that he could make that within 30 days?
45 days.
Not a problem with me. All right, so we'll make that 45 days to make that reduced fine amount. There is also the $50 fee, so it'll be $3,050. It'll need to be paid within 45 days. In the event the reduced fine amount's not paid within 45 days, as well as the administrative fee, the original accumulated fine amount of $37,500 will be reimposed. Is there something?
I just want to be clear that fine has to be paid before a release of lien can be completed.
Yeah, that's fine.
Okay.
Yeah.
Okay.
Yeah, we'll do that. Yeah.
Yeah, they got to get their money first before they release anything. So, all right, 45 days, $3,000 in reduced fine, $50 administrative fee. Did I miss anything? All right. Any questions? All right. Thank you both. Have a great day. All right. Still good to keep pushing forward?
Yeah,
All
let
right.
me,
We got,
I'll knock
case
this one out quick.
CE 25-01970. This is property owners William and Brittany Franck, Franck. The address is 183 Patina Boulevard in Inlet Beach, Florida. Is anybody here on behalf of the property owners, the Francks?
They're not, they notified me prior to the case, or prior to the hearing, they would not be able to make it.
Okay, did they request a continuance or?
They did
just-
not, actually. They requested 45 days to come into compliance. They're almost there. They have a restoration plan approved at this point, and they're having trouble finding certain plants that were implemented for their restoration that their arborist submitted. Right now, that arborist is now revamping the site plan to put in new plants that are more localized to be able to implement that, and they're requesting 45 days to be able to come into compliance for that.
Well, let's go ahead and go over.
Go over everything?
Yeah, just, I don't know if we have to go over everything, but if you want to go ahead and give me the high points on the alleged violation, and you can introduce your packet into evidence.
Yes, sir. For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony in regards to case number 25-01970. The property is located at 183 Patina Boulevard in Inlet Beach. Property owners are William and Brittany Frank. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 4.06.01 preservation permit. The complaint came in on December 15th of 2025, and we received a complaint stating that they had cleared the backyard and brought in sand to install pavers. On that same day, I spoke with the property owner, and he granted access to his property for inspection. On 12/16 of 2025, I conducted initial inspection of the property and found the rear of the property showed no evidence of tree removal, but a small area, approximately 20 feet by 15 feet, was covered with a thin layer of white sand. After research, I found that from the back porch to the property line is a preservation zone according to the plat. On January 7th of 2026, a notice of violation was given as prescribed by code. On January 29th of 2026, a pre-application meeting was held with the property owner and Brad Bone from the planning department. On March 2nd of 2026, I spoke with Mary Niehaus, which is I can't pronounce her last name, it's Niehaus. That's the arborist or landscape architect who was hired by the property owner for the restoration application. On March 4th of 2026, a notice of violation extension was requested and approved with a new compliance date of April 8th of 2026. On March 10th of 2026, a restoration application was submitted, and on April 7th of 2026, a restoration plan was approved. On April 11th of 2026, a notice of hearing was given as prescribed by code. I've reached out to the property owner and the arborist several times since that approval for the timeline, and I hadn't gotten a response until Monday. When I talked to them, when I talked to the property owner at that time, he had said he had been in the hospital. That's why I had not heard from him. And he let me know that the landscaper that was going to install the restoration plan was having trouble finding some of the items that were on their restoration plan, which I explained to you earlier. The photos in the packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
All right, that'll be accepted.
Recommendations are 45 days to achieve compliance or a $250 per day fine to accrue with a $113 admin fee. And that might actually, I wrote that on here, but I think that's incorrect.
The 113 is incorrect?
It's a $122
Yeah, I have on
admin
your,
fee, I'm sorry.
Worksheet on the very last page of your packet is listed as 122. Does that sound correct?
Yes, sir.
Okay. All right. Anything else?
No, sir.
All right, thank you, ma'am. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 183 Patina Boulevard in Inlet Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is sufficient evidence to find a violation has occurred at the property, specifically a violation of 4.06.01, preservation permit requirement. Based on the county's recommendation, I'll find that the property must be brought in compliance within 45 days. We feel comfortable that the arborist or, whoever, environmentalist that's working on getting alternative plants is going to have that within that time? Yes. Okay. What's 45 days out? All right, so they're going to get a little extra. 29th, June 29th. So on or before June 29th, property owner will need to bring the property into compliance. If the property is not brought into compliance on or before June 29th, a $250 per day fine will be imposed. In addition to the fine, there is a $122 administrative fee. That fee will need to be paid within 30 days, regardless of whether or not the property is brought into compliance. And I have signed that order. All right, that'll close that case. Our next case is number 10 on our agenda. Property owner is listed as the estate of Deborah and Donald Hager, maybe? Is that right?
Yes, sir.
Okay. Whenever you're ready.
And for the record, I'm, Sarah Matrano, Code Compliant Officer here in Walton County. I'm here to present the case number 25-00151, parcel number 22-3N-20-28000-010-0010. The violation cited is for RV living. It is violation 2.02.00P. On March 9th, 2026, I was assigned the case for 302 Nolling Road. On March 10th, 2026, I conducted my initial inspection and observed several RVs and campers located on the property. Based on the water storage tanks outside of the campers, household garbage, dogs, and people coming in and out of the campers, it was determined campers were lived in. On March 13th, 2026, I returned to the property in an attempt to make contact with someone associated with the case. I briefly spoke with a man who identified himself as Ben, but he did not want to speak with me any further. No responsible party was located. On March 20th, 2026, a notice of violation was sent via certified mail to the property. Delivery was attempted, but no one was available to sign for it. NOV was posted on March 21st, 2026 on the property. On April 10th, 2026, a notice of hearing was mailed and posted on the property as well as the South Walton courthouse. On March 12th, 2026, I conducted my final inspection and found no change in the property. The violations remain unresolved. This property is already being adjudicated and accruing fines for building permits, exterior storage of non-operating vehicles, junk and debris, also for dilapidated structures, and a public nuisance. I have that final order in front of me. I know that's not part of your packet.
That's
if you
fine.
wanted
I
to
mean,
see
I can take your testimony as it is, but this is just for the RV living, correct?
Yes, sir. We're, the violation the only violation that I observed on the property that hasn't been adjudicated is for RV living. And we recommend 30 days to achieve compliance or a $250 per day fine to accrue. And there's going to be a $122 admin fee.
Now this, what's the size of this property? It's not large enough? Don't you have to have like 5 acres or more? if you wanna
Yes,
do
sir,
RV
and it's
living?
not large enough. There's also no dwelling on there that's permitted as a structure, a single-family structure. And I wanted to note this as well. If you look at the initial inspection, and we're looking at that far back property, the initial inspection to the final inspection, and it's actually getting a worse.
All right. And did you want to introduce your packet into evidence?
Yes, sir.
All right, I'll accept that into evidence. All right, anything additional?
Yes, sir.
All right, thank you, ma'am. And we don't have any representatives for the estate of Deborah and Donald Hager?
No, sir. And for the record, when I went to the property, there was again, I don't know who belongs there, who's in charge of the property, but someone had mentioned that the head of the estate was in prison. So they didn't give me any details regarding that as well.
All right, thank you, ma'am. All right, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 302 Noling Road in Defeniak Springs, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that there is sufficient evidence to show that a violation is occurring at the property, specifically a violation of Walton County Code 2.02.00P as in Peter, RV living. Based on the county's request, I will find that the property must be brought into compliance within 30 days. That'll be June 13th. Is that right? It's not on a weekend, right? Okay, June 12th. On or before June 12th. Property is not brought into compliance on or before June 12th, a $250 per day fine will be imposed. In addition to the fine, there's a $122 administrative fee. That fee will need to be paid regardless of whether or not the property is brought into compliance. The property owner will have 30 days to make that payment. All right. Our next case, excuse me, is 2501942 Erica Rice. All right, and Mr. Ufelder, you represent Ms. Rice. All right, or Officer Forehand,
Yes,
whenever
sir.
you're ready.
Yes, sir.
Go ahead. Yeah,
All right.
whenever you're ready.
All right, now Code Compliance Officer Greg Forehand, for the record, I'm submitting my final summary report, presentation, and testimony in reference to case number 2501942. Properties in the unincorporated area of Walton County and subject to Land Development Code Chapter 7, located at 4617 U.S. Highway 90 East, Defeniak Springs, belonging to Erica Rice. The primary or initial violations listed were 1.1309E, sign permits, 1.1300A, development approvals, 1.1309C, building permits, and 2020K, home occupations. Since some have been rectified. Complaint was received on 12/1.
Hold on 1 second. So you're saying the home occupations is not?
I have a listing of those that's been rectified. 2 have been rectified since the initial. Today, we're only going after development approvals and the home occupations.
Okay, go ahead.
Okay. On complaint received on 12/1/2025 regarding several businesses being operated out of a residential area. On 12/5/2025, initial inspection was completed by the original officer, CCO Bennett, with a notice of violations being mailed and posted on 12/13/2025. On 12/30/2025, CCO Bennett had a phone interaction with Ms. Rice discussing the current and prior cases, with him advising he would attempt to schedule a meeting with planning and try to establish a concise path towards compliance. On 1/5/2026, I received Officer Forehand received the case reassignment, making my initial inspection and direct contact with Ms. Rice on 1/28. We discussed her plans and moving forward because It didn't appear any business activity or signage had been removed. She advised she'd had intentions of seeking a zoning change to allow the commercial activity. On 2/5/2026, I received a call from Ms. Rice advising she had a pre-application with planning in reference to the lot split or lot shifts needed, and then rezoning to commercial. Continued inspections and interactions had taken place, and with the business activity continuing, and there's also been many updates and interactions and activity in the planning portal. On 3/26/26, follow-up inspection was completed, and notice of hearing was issued initially for last month on 4/8/2026, and posted at the courthouse on 3/27 for that. But on the 4/8, she had acquired her representation just prior to the hearing, and we got a postponement to this date on 5/13. But since the 4/8 hearing, we had multiple interactions, which they made some alterations, and they did get the signage taken down, so I was able to remove that violation. On yesterday, on 5/12, I did a pre-hearing inspection and showed violations to be present with the U-Haul still being there and some of the inflatables. Staff recommends 90 days and a $200 day fine until it's brought in compliance. I would like to submit my packet into evidence.
Felder, did you get a copy of the packet? Any issues? Yeah, that's the one I have.
Yes, this packet. Yes, sir.
Any, he's going to submit that into evidence. Any objections or issues that you want me to? Okay. I'll accept that into evidence on behalf of the county. So is this their, so we have development approvals that's related to the businesses that are ongoing?
Yes, sir. They're currently in process of doing a lot shift. They had 3 residential lots there, and they're shifted it into 2 to leave 1 as residential. And they're going to then do a DO approval and then a zoning change to convert the other one into potentially a commercial lot, from what I'm understanding, and move all the inventory to the western lot or the eastern side lot for commercial use.
And what's the status of that now? Or do you?
They've been in a bit of a quandary back and forth with planning to try to get an understanding. They've got the surveys done and down to the point of the division, pretty much, from what I understand. It's just been an entanglement with them going back in the planning portion of it.
So the activities that are currently occurring on the property are not permitted or zoned?
Yeah, not for the business activity, yes, sir.
And then the home occupations, is that kind of
Yeah,
part and parcel of that?
Yeah, it's kind of exceeding the allowance of the home occ, and it's kind of outside the boundary of that, but not enough that they could pursue a CLUG, being it's not a commercial property.
All right. Mr. Ufelder, do you have any questions for Mr. Forehand? Yeah. Go ahead. Yeah, we don't have a microphone down there, and they record these. Okay. Thank you, sir.
One thing I would like to know, we did do a public records request and asking for all documents related to this property, and then we just get, my client just got today or yesterday, we'd asked for all documents regarding this property, and she was able to get from the county a printout from, part of what this case is about is that there was a previous case in 2024 for these same issues, and there was representations made that she relied upon, and we now have a calendar entry of May 22nd, 2024 with Mr. Carpenter, Mr. Glidewell, and Ms. Rice. I only have one copy. I just got that, so I know we had already got one continuance, but this is kind of problematic that the last continuance was based on a public records request, and I got a lot of documents, and I reviewed them all, and then I just get this this today, provided to my client through the county, so.
So are you requesting another continuance, or?
Well,
are
it
we
is,
gonna-
the crux of this case is that this project that was looked at in 2024, and if you look at the inspector's note, it was closed because she was given recommendations by Mr. Carpenter, who is no longer here, Mr. Glywell, and other representatives that she complied with and followed. And it was represented to her that if she followed those, that as long as she was, which she did, she got a deeds change, she's lot split, she had to go to probate, that as long as she was doing that there wouldn't be an issue. And so it's really a large part of our case is estoppel. And so, yeah, I wasn't planning to ask for continuance until I was given this, because I'd like to get into more detail about, because my client will testify that she was, and we have dates and exhibits that she was specifically told that in 2024, that if she did certain things, that there wouldn't be, and then she complied, which she'd been doing, that there wouldn't be a code case. And so, and then now so that's, I'm just concerned that I don't know what else is out there in the public records, because this is a critical document, which confirms that on May 22nd, 2024, Mr. Carpenter, Mr. Glywell, and Ms. Rice met in Mr. Glywell's office, and that's, we believe that we have evidence to show what was discussed. I know Mr. Carpenter's not here.
Well, and what I'm trying to get to is, I want you to be able to present your case. Either you're telling me you're ready to present and you're going to go forward today, or you tell me that, hey, I would like a continuance because I've got documents, they haven't, and then I can make a decision on that. I want you to be able to present your case and not say, hey, you tied, one hand behind my back because of whatever. But, if you're not asking for a continuance,
No,
I'm fine.
yes, I am, because this is, we sent a very detailed public records request, we got documents back, and then this critical document was just given. Well, it was part of our we asked for any records regarding this property, and and the county is aware that our assertion, even in the documents, it says that Ms. Rice conveyed to the county that Mr. Carpenter and Ms. Glidewell said that it was okay, so.
Okay.
So I would ask for continuance. Yeah, I wasn't planning, but now that this came in, it is, I think we do need to get into more details about what was represented to her. I mean, obviously, my client is going to testify what she was told. The folks, Mr. Carpenter is no longer here in the county, and if you look at the case detail report given today, it says that.
Okay, well, let's deal with your request. What's the county's position on the continuance request by Ms. Rice?
Well, if you look on page 3 of my case report, it shows where I believe it was Supervisor King had spoke with Ms. Rice and reflected back on that meeting, I believe, with the director and Mr. Glywell. And a statement was made in there that the planning director allowed continued use of the property while the required applications were being pursued. For that reason, the original code case was closed. However, since the case was closed, Ms. Rice reported that one of her business partners passed away and there was delayed changes, but nothing was continued at that time. It was allowed to be. They allowed to give a chance at that time, but it halted it from that day forward until now.
I understand. So I guess I just want to address the continuance request.
Okay.
So Mr. Ufelder, on behalf of his client, Ms. Rice, is requesting a continuance because he feels he needs additional time to prepare his case.
Yeah.
Because of some documents, some public records that he just recently received that he believes are going to be germane and prudent or necessary for a full review of the case. I'm inclined to grant that, but I do want to hear from the county. I understand you were coming here today because you wanted to be ready to proceed.
Yeah.
So
2 months in a row.
I get it.
Yeah. Let me kind of discuss it with my.
Yeah, go ahead. I'll give you a moment.
All right.
And I know Mr. Ufelder, y'all have been waiting a pretty good part of the day, so I know asking for a continuance at this point's usually a tough pill to swallow, but.
Right, it was, it was just what we got.
Understood.
Yeah.
Let me ask this while they're asking or discussing it. I mean, would 30 days be sufficient time? I mean, is there any reason that we could not have this prepared and heard?
Yeah, as long as I'm not given, some other documents that, basically the case is about estoppel, that there was representations
No, I
made.
get that. I'm just saying.
As long as we don't get any more surprise documents the day before, I think that would be fine. I wasn't anticipating getting this calendar document the day of, so.
All right, Mr. Forehand, he believes, I don't know if you heard some of that discussion,
No,
but
sir.
asked Mr. Ufelder if he thought a 30-day continuance would be sufficient. He believes it would be, absent receiving any last-minute documents or things from the county. Do you have any reason to believe that there's any more documents that are pending? Is there requests that have gone unanswered at
We
this
sent a
point?
public record request right when I got hired, and then I got a large tranche of documents, and then we got this today.
No, I understand. What I'm getting at is, are you expecting another tranche of documents, or are we kind
I
of
may,
done at that point?
now that I got this, I may ask as more specific, like, anything related to this meeting that, now that I have the time at 10:30 on May 22nd.
Okay.
Other than that, I wouldn't anticipate anything. But there's even in the record, it shows that there's a 2024 case, and it says it's closed, but there's nothing that I've been given, there's no detailed report and I don't know if they do that for closed cases.
I don't either, so, I mean, we'll just have to rely on whatever the county
Okay.
produces. All right, I'm sorry, Mr. Forehand, I know you had
Well,
needed to discuss.
and that's what Georgina was asking, if we could, just let something else go before this, and while she's checking in a couple of stuff with our administrative assistant to see, what did come through. That's just a calendar date there? We just want to know if there was anything like documented with that or any kind of.
Oh, yeah, I mean, we just got this today. This verifies that there was, actually a meeting as on this date with Mr. Carpenter and Mr. Glidewell. I mean, we may want to talk to Mr. Glidewell and Mr. Carpenter.
Okay, I got you.
We sent a public records request to the county to cover all, so if there's emails or, it was a comprehensive request, and, this is just troublesome because this is, critical. If there's minutes from this, or the notes, or if we need, I don't know where Mr.
Right.
Carpenter is, so.
Yeah, and I'm reluctant to pass this because we got several more hearings today that we got to get to.
We made, my manager just advised we could go ahead and grant the extension.
So.
Continuance, I'm sorry.
Yeah, so based on Mr. Ufelder's request to continue this case so he can finish his discovery, I'm going to grant that over without objection from the county. And then that would put us at what date? Yeah, June 12th. All right. So, say what?
The next hearing is June the 10th.
Yeah, that's what we need.
That's
It's June
fine.
10th. All
Okay.
right, so we'll announce on the record that this case will be continued to June 10th, 2025, at this location. And because of that, I'll go ahead and ask that it be put as the first item on the
Okay,
agenda
thank you very much.
for that date. All right. Do you want to take this back, Mr. Ufelder? That way, if you
yes.
need to supplement, you can just add to that. And then I will say that since the county has already presented their case, I'll probably go ahead and start on that date with you presenting your case. And the county can obviously present rebuttal and any additional evidence it may need, testimony, things like that. But since Mr. Forehand's essentially presented the county's case for the most part. Be prepared for you to go first.
Just entering, okay.
Thank you very much.
All right?
All right, thank you.
All right. Our next case is 25-01-911. Mr. Forehand again drew the short straw.
Yeah.
The property owner is Victor Valdez, Lot 8, South 6th Street in Santa Rosa Beach, Florida. Do we have Mr. Valdez or a representative?
Hey,
Okay.
Good afternoon.
Good afternoon, yeah.
My name is Richard Arana. Victor Manuel is my father-in-law. I'm representing him.
All right, hold on one second. Your name is, say that one more time.
Richard Arana, Arana.
All right. All right, and you're here on, as Mr. Valdez is your son, or I'm sorry, your father?
Father-in-law.
Oh, father-in-law, okay. All right, what we're going to do is allow Mr. Forehand to present his case, and then I'll allow you to ask him any questions, and then I'll hear any testimony or evidence from you. So if you want to grab a seat, you can grab a seat while he goes on. All right, so Mr. Forehand, whenever you're ready.
I also took this number from another officer. I'm Code Compliance Officer Greg Forehand. For the record, I'm submitting my final summary report, presentation, and testimony reference to case number 25-01-911. This property is in an unincorporated area of Walton County and subject to Land Development Code Chapter 7, showing as Lot 8, South 6th Street, Santa Rosa Beach, Florida, belonging to Victor Valdez. Violation is listed as a 1.13.008 development approvals, 1.1309 building permits, and 70201A junk and litter. Just for statement, the 1.1300A development approvals has been resolved. The complaint was received on 11/13/2025 for clearing building without permits, junk litter. Research showing plans in the portal awaiting review but not approved. Initial inspection was made on 11/18/2026, confirming the existing unapproved conditions. On 11/25/2025, notice of violation was posted and on hand delivered to a contractor at the site, Chad Patterson, and placed in certified mail. Inspections and monitoring of the portal. Inspections and monitoring of the portal continued with a stop work order being placed on the parcel on 1/14/2026, awaiting approvals for any further development activity to continue. On 2/5/2026, planning released approved BPR for a single-family home, resolving the development approval violation. On 2/17/2026, I had an interaction with a contractor in reference to moving forward with the building permits and the continuing cleanup of the junk and debris about the lot, with them seeming to be aware of the process and motivated for completion. With continued monitoring of the portal and the building permits and following with inspections, attempted to phone contact with a contractor and confirmed with the building department on 4/21/26 that there hasn't been any progress with the building permit. And then on 4/21/26, notice a hearing was posted at the property and courthouse annex for today's date, then mailed on 4/22/26. On 5/12/26, pre-hearing inspection showed the violations continued to exist. I would like to submit my packet into evidence.
That'll be accepted into evidence. Mr. Arano, do you have any questions for Officer Forehand?
I just see that the violation is junk and litter. I think we already resolved it. There's in the pictures, if you can see, there's just the part of the fence that we have to remove because we split the lot in two just to put the structure in the other lot. So I think that's the only thing we can see right now. It's just he said it's not a blight condition, but once we get this resolved, we have to put that fence back for privacy because it's now two lots dividing the property.
Are you talking about this part of the fence?
Yes, the one that's reclined to the.
Yeah, okay.
So that's basically the only thing left. Everything else is we rent a dumpster and we took care of.
Hold on, and do you have any specific? I'll let you testify, do you have any questions for Officer Forehand?
Yes.
Okay.
But I
What are
wanted
your
to make sure.
questions? Yeah, what
so
are his?
for about that's the only thing that left, or there's other stuff.
That fence construction, it's considered construction debris or fence debris, being it's the way it's zoned, anything you can see like that in South Walton is considered blight or debris, you know.
So we planned to put the fence back, but since we received an order to stop working, we just rather, left it there until we decide what to do with the property.
Could they move that? Like,
Oh, they could erect the fence under that, yes, sir. A correction of that nature, because that didn't require, a fence didn't require permitting.
Okay, I just want to make sure. And
all
then
right,
I have
is there, hold on, was there anything else besides that part that needs remediation?
Not really. The fence panels, and the rest of the items was very minimal. A couple like buckets and things, but it's mainly those panels those there on the side. Most of it you could tell was like bicycles and average use things.
Yeah.
And you understand that if you decide to re-erect the fence or you remove it, you still have to have code come out there and confirm that that's been done, assuming there's a code violation.
I wasn't aware of that.
Okay, well, we can talk about that, but go ahead. I'm sorry, do you have any other questions?
Yes,
for Mr.
about the
Ford?
building permit, he said that we have contact with our general contractor, but we right now feel like we're stuck. So since we split the lot into, we're right now in the process of getting a sewage for a septic tank permit. Since, unfortunately, we don't have any service like water or sewage in this specific row. So that being said, we already contact a private provider for septic and say that the DEP wouldn't approve a permit for septic tank to put 2 septic tanks in this in a row. So at this point, we would like to have a little bit of guidance what would do with this, because that's the process to get the building permit, and we just have that on the checklist just to get in sewage permit. Once we get it, as you see, we have submitted several permits to the development, and we're working on the building permit right now. So that's where we're at. That's why we haven't got any progress, because we don't know.
So, I mean, we're not here today to try to go through and figure out all the details on what you need to correct the property or so I'm just trying to determine whether or not there's enough evidence to show that there's a violation occurring at that property. And I only have the one parcel. Do you know anything about this lot split?
That was on a prior, there was a prior case earlier in the year where there was a split to the one on the north side of the property. And then that's what it was. This building was on a lot that they own on the north side of that lot, and they shifted this building onto the south lot and done the split.
Okay.
And then this became a second parcel and
We're just
generated
dealing
this
with the
case.
parcel
We're
that has the south
just-
parcel?
Yes, sir.
Okay.
The other one has already been to hearing and adjudicated.
Okay, so at this point, there are claims, Mr. Arana, that you don't have the proper building permits in place, and we've talked about the junk and debris. So, sounds like you've applied or there's been an attempt to move to get the building permit requirement. Do you have any evidence or testimony that would dispute that you even need a building permit or anything else that you want me to consider related to the building permit part?
Like I said before, we're stuck in the permit right now, so I would like to get a little bit of continuance so we can get a little bit more time either to decide what to do with this permit with septic tank, because that's probably the only thing we're missing right now. Okay. Because we already got the plots and everything. The contractor couldn't be here today, but he obviously got on file.
All right. So you're not necessarily disputing that you need a building permit, you just need time to try to work through that process?
That's correct.
Okay. Based on that, how much time are you requesting, or do you believe you will need to bring the property, or try to get that building permit, and also deal with the fencing or junk and debris issue?
Yeah, like I said, that's the only thing we got on the fence. If we either trash it or because either we put the fence back, but we didn't know what to do, so we just lifted there like you see in the pictures. But if you said we can put it back, that will be resolved like in a day or so, you know.
All right.
And then, but for the building permit, I would say probably 60 days.
All right. What's the county's recommendation, Mr. Forehand?
If they feel they can get it done in 60 days, it actually be 61 with my schedule, which would put it at 713, with I've got $150 a day thereafter.
So you have no issue with it, with this 60 days or 61 days?
No, sir.
Okay.
Yeah, because I did have interaction with and it's like all my communication lines fell off. And if you like my phone number, we can get that. So communication goes a long way.
That works.
All right, and what was the requested per day fine if it's not?
150 and administrative fees of 122.
All right. Mr. Arana, the county's requesting that you bring it in compliance within 61 days, which would be on or before July 13th. If you don't bring the property in compliance by that date, a $150 per day fine will be imposed, and there's 120. Do you have any comments or on that?
Yes, if we are not able to get the permit due to the DEP, because, we already, like I said, we already get the septic tank, but there's one inside that's in between the two lots. So if we don't get the permit, then we have to remove the building out of the property.
Yes.
That would likely
it would have to
be
be
the
taken
outcome.
back to just a vacant lot. Yes,
Okay.
sir.
All right.
Okay, any other questions?
No, sir.
Okay. Thank you both, gentlemen. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 55 6th Street, Santa Rosa Beach, Florida, I'm sorry, let me take that back. This doesn't have an address, right? This is just
It's just a
identified as
lot currently.
8. Okay, because of the split, they don't have a 911 address
No,
issued
as of
yet.
yet.
All right, so the property identified as Lot 8 South, located on South 6th Street in Santa Rosa Beach, Florida. Parcel ID number 22-2S20-33-120-113-0080 is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find sufficient evidence has been presented to show that there is a violation occurring at the property, specifically a violation of the Walton County Land Development Code 1.13.09C, building permit requirement, and 7.02.01A, junk and debris. Based on the request of the county, I'll make a finding that the property must be brought into compliance on or before July 13th, 2026. If the property is not brought into compliance on or before July 13th, 2026, a $150 per day fine will be imposed. In addition to the fine, there's a $122 administrative fee. That'll need to be paid regardless of whether or not the property is brought into compliance, and that'll need to be paid within 30 days. I believe that covers everything. Did I miss anything?
Sounds good.
Do you have any questions, Mr. Arana, regarding the order or the timelines?
No, sir.
Best to you. Thank you.
Thank you.
All right. The next case we have is 26-00111 John and Casey Bain, B-A-I-N. The address or the location is East White Rose Street in Defuniak Springs, Florida. Do we have anybody here for the Bains, B-A-I-N-S? Or, I'm sorry, B-A-I-N. All right.
Good afternoon, Your Honor.
Whenever you're ready. Yep. Good afternoon.
Officer Harold Serrano, Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony for case 26-00111. Location is Lot 18, East White Rose Street, parcel number 17-3N20-2808085-0180. Owners John and Casey Bain. This property is in an unincorporated area of Walton County and is subject to Land Development Code Chapter 7 County Ordinance. Violation cited is 1.13.00A, development approvals, and 7.0201, junk and litter. On February 17, 2026, a complaint was filed for the property regarding junk and debris and scattered throughout the premise. The complaint also reported buckets and other containers collecting water, as well as utility trailer on the property that appeared to be lived in. On February 18th, I conducted an initial inspection of the property. Upon arrival, I observed junk and debris scattered throughout the site, including items placed within the right-of-way. The property has also contained a small shed and a solar device contraption, both of which were not permitted. as the parcel is designated as a vacant lot. On February 27th of 2026, notice of violation was posted to the property and a certified mail copy to the owner. March 11th, 2026, received a call from the property owner, Ms. Casey Bain, stated that she had received a notice of violation, requested clarification as she currently resided in Ohio and has no relationship with John Bain anymore. I explained that she would need to get the property cleaned up and remove the items, stated to bring it into compliance or obtain an appropriate development approval if she intended to keep the structure on the property as far as regards to the shed and the solar contraption. On March 13, 2026, I received another call from Ms. Bain informing me that her parents, Mr. and Mr. Hatter, were on the property and that the area made contact with them on site. I was in the area. They were planning on cleaning up the property due to the fact that the parents were residing in Panama City, so it was more convenient as she was in Ohio. On April 1st, I conducted a follow-up inspection. Significant improvements had been made. The trailer located in the right-of-way had been removed, and the majority of junk and debris had been cleaned up and removed from the property. However, observed the small structure and a small shed and some minor debris still remain on the property, making it not vacant completely and not in compliance.
Did you speak to the parents or the property owner? Is there a plan on that?
They had informed me last week they were going to try to get back to it over the weekend, weather permitting. I had done a pre-hearing inspection on the 12th yesterday, and there is no improvement on that.
Do you want to introduce?
I would like to submit my packet and evidence.
All right, that'll be accepted. What's the county requesting?
30 days to achieve compliance, $250 per day for fine or accrue, and $122 admin fee.
I'm sorry, how many days to bring it into compliance?
30 days, please.
All right, thank you, sir. All right, I didn't see anybody else come in. No one here on behalf of John or Casey Bain. I'll close the evidence portion of this hearing. Make the following findings of fact and conclusions of law. I'll find that the property located, identified as Lot 18 East White Rose Street in Phoenix Springs, Florida, parcel ID 173N as in Nancy 20280800850180 is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. Based on the evidence and testimony presented, I do find sufficient evidence presented to show that there is a violation occurring at the property, specifically a violation of Walton County Land Development Code 1.1300A, development approvals, and 7.02.01A, junk and litter. Based on the county's request, I'll order that the property must be brought into compliance within 30 days on or before June 12th. Property is not brought into compliance on or before June 12th, a $250 per day fine will be imposed. In addition to the fine, there's a $122 administrative fee. Administrative fee will need to be paid within 30 days, regardless of whether or not the property is brought into compliance. All right. Our next case is property owner Marley Drummond, case number 26095. And location address is 126 Walton Way 1 in Miramar. Are you Ms. Drummond?
I'm Mariana Drummond, Marley Drummond's daughter.
Or Marley Drummond, I'm sorry. So you're Marianne, I'm sorry, what was that again?
Mariana.
Mariana.
Yes.
All right. And were you sworn in, Ms. Drummond?
Yes.
All right. If you want to grab a seat right up there, I'll allow the county to present, and then you can ask any questions or present any evidence you want. Thank you, ma'am. Whenever you're ready.
Officer Harold Serrano again with Walton County Code Compliance for record submitting final summary case report and testimony for case 26-00095. Location is 126 Walton Way, Unit 1, Miramar Beach, Florida, 32550. Parcel 19-2S21423100000010. Owner Marley Drummond. Property is in an unincorporated area of Walton County and is subject to Land Development Code Chapter 7 and the county ordinance. Violation cited is 1.13.00 alpha, development approvals, 1.13.09C, building permit. Complaint came in on February 10, 2026 for junk and litter. On February 12, 2026, conducted an initial inspection for the property, observed a mattress placed in the front yard at the rear of the property. In the back left corner, observed a shed located within the setback area and visible from the right-of-way, and observed an addition that appeared to have been constructed onto the existing home. Attempted to make contact at the front door, no response was received. Following the site visit, I reviewed aerial imagery on the county website. Based on the imagery, the shed and the addition appeared to have been installed roughly in the year 2020. I also confirmed at the building department that there were no records or any permits issued for these structures. On February 14th, a notice of violation was posted to the property. On February 26th, an updated NOV with the violation for the building permit was posted to the property, and certified copy was mailed to the property owner. During this reposting, I observed that the mattress and the trash had been removed of the property, leaving only the development approvals and building permit violations still active. And on March 11th, 2026, the property owner, Mr. Maude, visited the code enforcement office seeking clarification on the steps required to come into compliance. Explained that she would need to obtain development approvals through the planning department and a general process on how to come in compliance. We spoke with planning and she arranged an appointment for further assistance and direction. On March 19th, I contacted the property owner to request an update on the application, as I did not see any indication on our BPR portal application that was submitted to the parcel. It was later determined that the BPR application had been submitted, but there was an error on the parcel number, not in accordance with the parcel we have listed. On April 10th, that parcel was then updated through planning department, so it does generate that what we see, the application was submitted on March 16th. On April 10th, a notice of hearing was posted to the property. April 15th, it was certified mailed. April 21st, notice of hearing was posted to the courthouse. And April 12th, we did a pre-hearing inspection yesterday, and no changes or approved plans were submitted to that parcel. I request to submit this packet into evidence.
That'll be accepted. Ms. Drummond, do you have any questions? Okay, yeah, all right.
So we did apply for the building permit and everything. I did want to note my mother is in Brazil right now. She was in Brazil, and then she came back just to kind of figure this out, and then she had to go back. She's just trying to deal with some health concerns, so she's there indefinitely. So I wanted to ask, the shed that we are applying for the permit for, it's within the setback, so it'll have to either be moved or removed, but it's not like it's like a custom built shed, so we can't just like pick it up and move it. So she's trying to figure out what exactly she wants to do with that, but she's there now, so we wanted to ask, for the maximum amount of time you could allot for us to kind of figure that out, whether it be 90 days or I don't know if you can do more.
Yeah, I think I'm limited to 90. The other alternative, I think, and again, that would be up to your mother, is she can maybe seek a variance, but those are pretty tough to get. So that's an alternative as well, absent needing to move it or trying to seek a development permit. So you're not here denying the claims of the violation. You just need some time to get it sorted through.
Right.
Is that correct? Okay. All right. What's the county's request or recommendation on this?
Request 60 days to achieve compliance, a $250 per day fine to occur with a $122 admin fee.
Okay. So are you going to be handling this, Ms. Drummond, or is your mother coming back? You said she's going to be in Brazil.
Yeah, I don't know how
Definitely.
long she'll be there for. So I'm trying to. I've been in contact with Officer Serrano, and we've been trying to figure this out, and he's been super helpful. But just trying to figure out for her, but also needing the time and the resources, money-wise, to kind of get it figured out while she's there. So if you could grant us 90 days, that would be great.
Okay. All right. Anything else from the county?
No,
All
that's
right.
it.
And nothing else from you, Ms. Drummond?
No.
All right. Thank you both.
Thank
I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 126 Walton Way, Unit 1, Miramar Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I'll find that, based on the testimony and evidence presented, there is sufficient evidence to find a violation has occurred at the property, specifically a violation of Walton County Land Development Code 1.13.00A, development approvals, and 1.13.09C, building permit requirement. Based on the issues brought up by Ms. Drummond, I will honor her request and allow for 90 days to bring the property into compliance. When would that be? So the property need to be brought into compliance on or before August the 11th. If the property is not brought into compliance on or before August 11th, a $250 per day fine will be imposed against the property. In addition to the fine, there's a $122 administrative fee. That fee will need to be paid within 30 days, regardless of whether or not the property is brought into compliance. Are there any questions regarding the order? All right, you understand the timelines, Ms. Drummond, and I would just stay in contact with Officer Serrano so you can try to hopefully get this resolved as quickly as possible. Best of luck to you. Thank you.
Thank you.
All right. Next case, QA Holdings, and that's 260074 is the case number.
Yes, Your Honor, respectfully, if we could request that the next three cases be presented together. All properties are adjoined lots. They were all cleared at the same time as part of the same project, and they all connect through the LLC ownership.
So I've got 15, 16, and 17. Case number 26074, 26078, 26079.
That's correct.
I have the property owners listed for at least 15 and 17 as Q&A Holdings. That's lot 21 and lot 22. And then there's a lot 23 that's listed as Vicky Cow.
Correct. Three of the separate orders, let's see, for the record, the recently learned that Lot 23 was a quitclaim deed to Vicky Chow, the LLC's registered agent. That's why we're still requesting out to be seen out, because they are all together related.
All right, so, and
And
we
I
have
bel-
some representatives here for Q&A, or QA Holdings?
Yes.
All right, and who are you, sir?
I'm Chen Cow, I'm her husband.
Chen Cow, okay. And do you have any issues with hearing all of these at one time, since it sounds like it might involve the same set of facts, maybe to try to
Yeah, we're good.
expedite things?
We're good.
Okay, good, thank you, sir. All right, we'll allow the county to present, and then we'll hear any testimony and evidence you may have. All right, whenever you're ready.
All right, for record, Officer Harold Serrano, Walton County Code Compliance, submitting my final case report and testimony in cases number 26-00074, 26-00078, and 26-00079. Due to the fact that all three parcels are involved are owned by the same property owner, registered agent under the same LLC, the county and myself will present all three cases at the same time. Okay. Property locations, lot 21, 22, and 23, block 94 on North 14th Street, town of Santa Rosa Beach, Florida, 32439. Parcels 222S-20-33120-94.
And Mr. Officer, I've got those
Okay,
parcel IDs, so you can
excellent.
go ahead and move over. Yeah, go ahead. If you want to just move on to the facts and the alleged violations.
Violations cited is 1.13.00 alpha development approvals. Complaint was filed on February 6, 2026 for clearing lots without permits. February 6th, I conducted an initial inspection of the property, observed that the lots had been cleared without proper development approvals. Stop work order was posted to the property at that time. February 10th, 2026, I made contact with the property owner's husband, Mr. Chow, who is listed as the applicant on the BPR applications. I informed him that each parcel requires its own separate BPR application and approved before any work can continue. Stated the understanding, informed that he was out of town, but would contact the plan department. On February 13, 2026, Mr. Chow came to the code compliance office to discuss the violations. I again explained that he must obtain development approvals for each individual lot that had been cleared. He stated that he intended to go to the plan department to address the issues, and I informed him that the situation would be reevaluated closer to the compliance due date of March 15th. On February 13th, individual notices were certified mailed to the property owner as well as the registered agent and posted on the 14th. The notice of violation were posted on the On February 14th, the notices of violations were pushed to the property. On February 26th, I conducted a follow-up inspection, and no changes had been made since the previous inspection, and the stop work order remained posted. On March 16th, a status update, planning approval process for the updated PPR applications for Lot 21, 22, and 23 had been performed. At the time, no plans had been approved. On April 10th, 2026, a notice of hearing was hand-delivered. During the interaction, Mr. Chow expressed concern that the work required to come in compliance would take several months due to the conflict with the state and a DEP permit. Yesterday, May 12th, 2026, conducted a pre-hearing inspection. No changes had been made and no approvals had been made to the parcels. I'd like to submit my packet into evidence.
All right, so I've got 3 packets, one for each case number. Most of them appear to have a lot of the same information, photographs. Is there any objection, Mr. Chow, to me accepting any of these or all of these into evidence?
I'll go ahead.
Okay, so those will be accepted. Do you have any questions for Officer Serrano at this time?
Well, I was just going to show him that when we bought the lot, it was just 2 lots. And one had a burnt mobile home in it, and we applied for a building permit for that one, and we got it. And then we also applied for a building permit for the next one, so it's actually only 2 lots. But during that process, realized that we could actually split it. So once we split it, that's where, you know what I'm saying? That's why you see so much code compliance, because it's only supposed to be 1. So then we got Public Works to approve to us to clear the right-of-way. That way we could, get the other mobile home in, but then my wife decided not to do it no more. She decided to go ahead and build homes instead.
So that's the plan, is to build 3 homes on the 3 separate parcels?
Yeah, we actually just got the plans back like last week. So this has been updated in planning. We got this B-zone certificate back like the 9th. It's right here.
Okay.
I can show it to you. Right here, and that's when Tracy, because I just talked to Tracy last week, and she told me this is the last piece that she need to go through the flood zone planning. So this is the last piece right here, and she, as you can see up there, is dated the 9th, which is 4 days ago that I just got it back.
So I guess my question to you is, you don't deny that you need development approvals for the lots so you can construct. Is it similar to the last one, you just need some time to try to finish getting things?
Yeah, we're just waiting for
taken
the
care
state to come to impose their impact fees. And once they impose the impact fees, then, but I don't know how long they're gonna take, because it's the state. But anything with the county-wise is done.
Okay. So again, you're not disputing you need development approvals for all 3 of these lots. You just need some time to get that, if you've already submitted it, for the county to review it, whatever state requirements or impact fees may be imposed. So it sounds to me like you're not denying it, you just need some time to get it. Okay. What is your request on how much time do you think it's going to take you to get the permitting and everything done? I know you don't control how fast the county works. I know you don't control how fast the state works, but what do you think would be a reasonable amount of time?
Well, the state's gonna take 9 months.
Okay.
I know you can't give me 9 months. So, I mean, I'm stuck in a pickle.
Understood. Well, and what I will say is, we can give you an amount of time. If you go past it, and you can come in, and I don't know if you were here earlier, but you can ask for what's called a fine reduction at some point. But yeah, I mean, we want you to continue to work, not just say, throw your hands up and say, forget it.
No, it's actually, we put the application in already, so it's in the works.
Good.
We did it since January.
Right.
So it's in the works. And also, if I can't get it done in time, and if you do impose a fine, I would like just offer 1 lot instead of 3 fines.
Well, yeah, it doesn't work that way. The law says whenever you get a fine on any of your property within the county for code violation, the state law says when they file that, it attaches to all your property in that county. And And if they find out you got property in Okaloosa, they can go file it in Okaloosa and attach that property.
Yeah,
So, and again, that's not me, that's not the county, that's just state law. That works anywhere in the state of Florida that you go to.
But I did get a building permit for when I bought it, I applied for both building permits and got it, but just the problem is when I split it.
Yeah.
So, you know what I'm saying? We were in the process of getting a building permit to get the second one. The first one was done. You see what I'm saying? So we cleared it, but we had a building permit. So that's what I'm saying. If you do get finders, instead of 3 separate violations, can we just reduce it to 1 violation since they're all you see what I'm saying?
Well, yeah, I mean, right now, they're treating each lot as being cleared and each lot requiring a building permit. Because the idea, and you may have heard it from others, is you're not allowed to go start clearing your lot without a building permit, right? A development order is probably what you're familiar with. So I can't go, especially if it's property on the south end, and just start clearing and saying, oh, I'm going to go get my DO in a year or 2 or 3 months or 4 months. You actually have to have that in your hand before you start cutting down trees and clearing the property. And I'm looking at the photographs, and unless you're telling me this is all one lot.
It was 1 lot.
Right, I get
Yeah.
it, but I'm saying that's no longer the case.
No, that's what I'm saying.
There's 3 lots.
Yeah.
So we got to treat each one individually. Now, if you go combine, if you want to fuse the lots back and make it 1 lot, then that's a different story. But as we sit here today, it's 3 lots. So that's why they got to bring 3 cases, right? Because if they only bring 1, and I issue a code violation, it's only going to go to that, be found on that one. But then if you don't get it complied with, then it attached to your other 2. So, I mean, I understand you're in a pickle, and I'm inclined to try to give you as much time as I can, because it sounds like, you've got a plan, you're working towards that plan. Sounds like pieces are falling in place, and, fingers crossed, things will move quickly. But I also understand you don't control how fast the county works or how other people work. You can just get your stuff submitted as quickly as you can and cross your fingers at some point. So, but yeah, I'm inclined to, I'm going to listen to the county as well, but I'm inclined to give you as much time as I can.
Okay.
All right. Anything else? I didn't mean to cut you off.
No, it's not.
All right. Anything else from the county? What's the county's request or recommendation on this?
No, we recommend 60 days to achieve compliance, $250 per day to fine accrued, and $122 admin fee.
That would be on each property?
Yes, sir.
Okay. All right.
And the reason, because there has been other instances with other properties, it just wasn't adjudicated out. So we feel that 60 days is more than enough with the previous cases he has been warranted on.
Okay.
Okay.
Okay, yeah. What's your name, sir?
Mr. Roberts.
Mr. Roberts, come on up to the microphone. And have you been sworn in, Mr. Roberts?
Yes, sir.
Okay. And what do you have for me this
So would it be
afternoon?
more beneficial for us to combine the lots together going forward till we get this sorted out with the DEP? Because we're, like he said, we're waiting on wetlands impact fees, and it's going to take forever.
Well, I think, I can't give you legal advice, so that's really maybe a better question for
But if
y'all
we
to sit
did put them
down.
together,
But what I'm getting at
will it
is,
be one
it's
fee?
either gonna be one property or it's gonna be all property. Like, there's no way that as I sit here, I can figure out a way that you can say, oh, well, it'll just affect this part of the property, right? So whether you have it all 3 split up or you have just one big lot, if there's a violation and the county file their code lien, it's gonna be that. If you go buy a property next week, right, then it could attach to that lot as well, or that piece of property. So it's not really like, oh, well, let me combine it, and that's somehow gonna, limit our exposure. I think your exposure is there regardless.
Right.
But again, I can't give you legal advice, but I mean, just looking at it, I don't think that's gonna be some sort of silver
Already
bullet
in
for you.
3 separate cases, it won't change it, the matter.
Yeah, like it would, even if you fuse it, it's
Okay.
still gonna have attached to those properties.
So at the end of if we get 90 days, at the end of the 90 days, could we request another 90 days if we're still waiting on the?
No,
on the
that's not
state?
how it works. No, well, normally we just, there's gonna be a cutoff, right? And then the idea is that you continue, because, you may change your plans, right? You may just say, hey, we're gonna do something completely different, which is fine, you're allowed to do that. But, what we do is we look at, are you continuing to try to resolve the issue? How long is it taking you? Are you dragging your feet? Or are you trying to work as diligently as possible? And we all recognize, as I said earlier, you don't control all the things in the world, so you don't know how fast other people are working. But I'm assuming you were here for some of the others, so, we'll take into account, hey, some of these things, we gave it to them, they wanted it on this date, we gave it to them, and it took them 60 days to look at it, and we had done everything we could, so, those factors, mitigating factors, we'll take into consideration. So I'll give you as much time as I can. I can't, we're not gonna just kind of,
That's all we're asking
lack
for.
of a better term,
Appreciate it.
kick it down the road, the can down the road, but, we need to have some finality. County deserves that, you guys deserve that as well, so, did that answer your question? All right, anything else, from Mr. Roberts, Mr. Chow, or the county?
Not at this time.
Okay, thank you all. All right, at this time, I'll close the evidence portion. And this is going to be closing the evidence portion for case 26078, 26079, and 26074. Based on the testimony and evidence presented and these findings of fact and conclusions, the law will be for all three of these parcels and cases. I'll find that there is sufficient evidence, or let me do this first. I'll make a finding that all the lots that have been identified are in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I'll also find that there has been sufficient evidence presented to show that there are violations occurring on each of the lots, and the violations are consistent on each of the lots, and that the violation is a violation of Walton County Land Development Code 1.13.00A, development approval. The request by the owner for 90 days, I will find that is reasonable considering the circumstances. That's going to put us at August 11th. So on or before August 11th, all three parcels will need to be brought into compliance. If the properties, any of the three parcels that aren't brought into compliance on or before August 11th will receive a $250 per day fine. In addition to the fine, there's a $122 administrative fee. Since we heard all these together, is that $122 for each one?
Yes, sir.
Still? Okay. There's a $122 administrative fee for each case number. That means it'll be times 3. I'm going to give you 60 days to pay that just because of the number, but you can obviously pay it earlier if you want. That'll need to be paid regardless of whether or not the property is brought into compliance. And I wish you the best of luck, and I will sign those orders. Do you have any questions regarding the timelines or the amounts imposed?
Oh, sir.
All right. Sorry you guys had to wait so long. Best of luck to you. Hopefully you'll get everything resolved quickly. Yep, thank you guys. All right. I think we're on our last open case, and that's 260128. Proper owner is Chris Fulner.
The Cottage of Camp Creek Condos Association, Condos Owners Association.
Oh, it's in the.
He was a president.
Okay, so he's just the president, but the property owner is listed as the condo association?
Correct.
All right, and are you how do you pronounce your last name?
I'm Charles Bunton. I'm
Oh.
actually a volunteer treasurer because Chris couldn't be here.
Understood.
Yes,
So
sir.
you need to tell him you had to stay here all day, so he owes you,
I've
owes
been
you
messaging
something.
him.
Yeah.
Sure.
All right, so you're Mr., is it Button?
Yes, sir.
Okay. All right, Mr. Button, let's try to get this one finished up for you. All right, whenever you're ready, Mr.
Again, location 8773 East County Highway 38, Inlet Beach, Florida 32461. parcel 27-3S-18167000000A0. This property is in the unincorporated area of Walton County and is subject to Land Development Code, Chapter 7, and County Ordinance. Violation cited is 1.13.00 alpha development approvals. Complaint was issued on February 25th for clearing landscape buffer without permits. Upon inspection on February 26, 2026, observed the portion of the landscape buffer on the east side of the development had been cleared, consistent with the complaint. At this time, there were no development approvals from planning or permits issued for the clearing activity. Upon further review of the aerial imagery, there appeared to be structures of some sort located within the landscape buffer on the north side of the property. This matter was to be addressed with the HOA president, Mr. Chris Fulner. On March 10th, 2026, I met with Chris Fulner, president of the Cottage of Camp Creek HOA, and hand-delivered the notice of violations. We conducted a walkthrough of the property, during which I observed that the designated landscape buffer on the north side had also been partially cleared and pavers were being installed within the required 20-foot setback. I informed him that these issues would also need to be corrected and that a restoration plan would be required through the planning department. On March 11, 2026, I received a phone call from Ms. Jenny Evans, a member of the Cottage of Camp Creek HOA, requesting clarification on the violations. I explained the process and the need to work with the planning department to develop and implement a restoration plan. On March 18, 2026, received a text message from Mr. Fulner informing me that he had met with Brad, the environmentalist from planning, to discuss the next steps for the restoration plan, and the application had been submitted. On March 31st, I received an email from Tiffany Landis, the secretary of Cottage Camp Creek HOA. She informed me that the planning application meeting had been scheduled to move forward with the process. Unfortunately, there is no significant approvals or any restoration implementation at this time. April 15th, a notice of hearing was posted to the property and sent via certified mail. April 26th, the notice was posted to the courthouse. And yesterday, May 12th, a pre-hearing inspection conducted. No changes had been made or restoration plan had been approved or implemented. I would like to submit my packet into evidence at this time.
Mr. Button, have you had an opportunity to get the packet, review any issues with me accepting that into evidence?
No, sir.
All right, I'll accept that into evidence. Do you have any questions for Officer Serrano at this time?
No, sir.
All right. Now's your chance for any testimony or evidence you want me to consider.
It was just an unfortunate situation. It was one of those where we hired a landscaper to come in, pull out some old vines, areas that we felt like were maybe a fire hazard, and things just got a little out of control and cut down probably way more than he should have. And then a disgruntled owner brought it to our attention. We tried to, say we'll do whatever we need to do to get it back. And so the complaint was filed, and now here we are. So we're kind of what you would call shovel ready to go, do what we need to do. We just need the green light to do it.
What are we waiting on from the county on this?
They did a maintenance plan application, and instead of doing the restoration, they would still need a maintenance permit to do the vine cutting and all, but the main restoration plan was not applied for. There's some communication wave on that. They've been very active in communication with me. I've been trying to get this settled, as well as talking with Brad via email. So they're on the right steps on it.
I guess my question is Brad going to come out or go out there and see?
Once they file for the proper application, he'll do his due diligence on it,
okay.
and then inform them what arborist advise the arborist of what plants need to be done. He did inform that the pavers would need to be removed from that north portion of the property. Again, the applications have not been just communicated correctly for them to kind of get on a good path on getting this.
How much time do you believe or would the cottages association be requesting on this? I mean, you guys sound like you're actively trying to work with the county and get things taken care of timely. I mean, do you have a sense of what you believe would be a reasonable amount of time?
90 days would be excellent. I feel like we'd be well under that, but just to be safe. And the pavers on the back, I just want to make a comment. You know, since 2001, when this development was done, there on the plat, there's a buffer of I think 20 feet. And that butts up right up against the building. So some areas were cleared just to put compressors back there. And these pavers, as far as I know, have been back there for like over 20 years. Now, that doesn't mean it's right or wrong, and if they need to come up, they need to come up. But they've just been back there for so
About
long.
These pavers? The
Yes,
ones
sir. Yes,
that
sir.
are-
And it's my understanding no trees were really cut down back there. It was just kind of vines and small bushes, but, you know, we want to be in compliance. So whatever.
Understood.
And as far as our inspection, Your Honor, is it what we see from the aerials out, from the changing throughout the years is what incorporated us to check on that. The pavers, unfortunately, Mr. Fulner also had stated that it was done before he was in charge of the HOA. So we just have to address all potential violations at the time.
So is that gonna be cleaned up, I guess, as part of the?
Yes, sir. According to Brad, once they do the restoration plan, application, he'll advise them further of it. As far as I know right now, through communication via email, that the pavers would need to be taken out. Now, that could change again with proper application and maybe another continuous meeting with him if they can do something different, or if when he does his on-site inspection and does see that the golf course portion of it does back up to that property, so maybe that vegetation, that's up to them. I can't speak on behalf of that.
I've been golfing out there. I wish I would clear out some of the vegetation. Killing me. All right, anything else from the county or from the condo association?
Not at this time.
Okay, and what's the county requesting?
We'll recommend 60 days achieve a compliance, or 250-day fine per day, with a $122 admin fee.
All right, thank you both. I'll close the evidence portion of this hearing. I make the following findings of fact and conclusions of law. I'll find that the property with parcel ID 273S18-167-00000000A as in Apple 0 is in the unincorporated area of Walton County, Florida, is therefore subject to the Land Development Code. Based on the testimony that was presented, I will find that there's sufficient evidence to show a violation has occurred at the property, specifically a violation of Walton County Land Development Code 1.13.06, post-development order and post-permit changes. Based on the owner's request, I will provide that the property will need to be brought in compliance within 90 days. I know the county requested 60, but I think based on what was presented, they are showing diligence and giving extra time. I don't think provides any harm or to the public in this case. And that's August 11th, correct? All right, so property will need to be brought in compliance on or before August 11th. Should the property not be brought in compliance on or before that date, a $150 per day fine will be imposed. In addition to the fine, there's a $122 administrative fee. I'll order that needs to be paid within 30 days. And I've signed that order. Any questions regarding the timelines or the fines? All right, appreciate it. Good luck to you, sir. Yep. And I believe that resolves all our open cases, so we are